The state of Michigan is now in session. The Honorable Adrian N. Young, the Honorable Rob A. Schwartzel, and presiding, the Honorable Marion Saad Hosby. All persons having business herein draw near to the attention and shall be heard. God save the United States, state of Michigan, and the sovereign.
Good morning, everyone. Welcome to the Michigan Court of Appeals. This is the first day of case call for panel 2 of the court's May 2026 session. Now, this morning, we're doing things just a little differently. We have Judge Adrian Young substituting in for Judge Mark Boonstra. We have Judge Brock Schwartzel and myself today. We are going to hear 2 matters slightly out of order because of the substitution, and then we're going to take a short break where we do a couple switches, and then we'll come back out and finish the 10 a.m. docket. Now, we understand that these cases are important to the litigants and counsel, and I want to assure you that they are important to us as well. We have been diligently working on these matters. We have had the benefit of your briefing, as well as the work of our research division and chamber staff. We are familiar with the relevant facts and pertinent law, and so we ask you to focus oral argument today on your most salient points, why you should prevail, and what is critical for us to understand. Finally, we are hearing matters involving sexual assault victims, personal protection orders, and children. Because these proceedings are recorded, we ask you to please use initials rather than the actual name of any victim, child, or other vulnerable individual in those cases. With that, we look forward to hearing your arguments. We'll resume by calling item number 1. That would be item number 8, case number 375918T, Serene Katranji versus Mark Savaya. Did I pronounce that correctly?
You did, Your Honor.
All right, thank you very much. Now, we have just plaintiff's counsel endorsed for oral argument. So you have 15 minutes, counselor. Go ahead.
Thank you. Good morning. May it please the court, Daniel Quick appearing on behalf of appellant Serene Katranji. The circuit court erred here and must be reversed. The trial court misapprehended the different processes of forfeiture versus foreclosure and misapplied the concept of election of remedies. Plaintiff had an absolute right to accelerate the indebtedness due under the land contract due to the default. None of those facts are in controversy. That right was taken away from the plaintiff by the trial court's error, and this court must reverse. In short, defendant defaulted on a land contract. All of that is uncontested. Plaintiff had the right to accelerate. All the preconditions for that were satisfied, and a notice of default was sent, accelerating the debt and declaring default. Once that was done, the plaintiff's right vested. Plaintiff had a couple options at that point as to what to do: forfeiture and foreclosure. Forfeiture, of course, is a summary proceeding in the district court. It's fast, but it has limitations. It only addresses what's been defaulted up to that date. It does not address accelerated indebtedness under 600.5726.
Counselor, have there been any changes since the trial court's decision in terms of, has the defendant made additional payments or anything like that? Or are we still at the same status as where we were at prior?
With regard to the property, defendant has continued to make payments, correct?
So if we agree with you, what would happen to those additional payments that defendant has made?
That's credited against the indebtedness. So there's no double recovery. And there'd be an opportunity for foreclosure at whatever the right price was. But in terms of the accelerated indebtedness, all of the payments made are all credited toward that.
I assume that defendant has not fully paid the land contract yet. I mean,
Absolutely.
made payments, but not in full satisfaction.
Absolutely correct.
Thanks.
Yeah. And that's really the point here. So even though there is a right to forfeiture, it can be taken away from the plaintiff by paying the amount that's due before the ultimate writ of restitution issues. And so this was made clear in Gruskin that there is no election of remedies until you actually get to forfeiture. And under the act, you don't actually get to forfeiture until that judgment's been entered and the writ of restitution's been entered. At that point, there's no contract, right? So it makes sense that you then can't also proceed under the contract at the same time. You have elected your remedy. And Gruskin talks about that. And this is where I think the trial court got confused, because there is older case law before the act was instituted that says merely uttering the word forfeiture actually effectuates that election of remedies.
Well, that's how
says-
the old common law
Ex-
operated, but there was a change in that with the statute. Correct?
Exactly right. And Gruskin talks about that in some detail. So the difference here, according to the appellee, is that because some money was paid after the forfeiture action was instituted, that somehow that changes the dynamic. And it simply isn't true. First of all, the district court case was dismissed without prejudice, which we all know bars nothing, nor is receiving funds to drop the forfeiture action and election of remedies to give up to this vested right to accelerate. This is made clear in the unpublished Bowen versus Bradley opinion, which we've attached. There, the land contract had an acceleration clause. The defendant defaulted. The plaintiff sued for acceleration and foreclosure. Defendant wrote a check for the past due, but not for the full amount with the accelerated balance. Court of Appeals held that the right of acceleration had been exercised by virtue of filing suit. And because that acceleration occurred before that check was written, the full amount was due. So here, the notice of default and the acceleration occurred back in November of 2024 before any money changed hands. That is not an election of remedies. And as we just discussed with Justice Schwartzel, or Judge Schwartzel, it's not an election of remedies because there is no double recovery. A variant of that was in the Sindlinger case, an old Supreme Court case, where there was a default, no acceleration had been declared, and money was paid and received. And then they tried to declare an acceleration. And the court said, no, you can't do that because that was cured before you exercise that notice. So you now can't vest into that acceleration and foreclosure remedy. So I think it is, so in the first instance, the trial court just simply whiffed on that analysis and got confused between those different remedies and the election of remedies doctrine. And there's no case in existence, nor cited by the other side, that supports an election of remedies in this fact scenario. This is why, in part, the appellee then tried to move on to some other doctrines. They claim accord and satisfaction, which the trial court mentioned, and waiver, but neither was presented such that it either could have survived the 2.116C10 motion that was filed, or at least as to the election of or the accord and satisfaction doctrine, the trial court's reasoning on that has to be reversed. As we say in the briefing, they can't satisfy any of the four requirements for that doctrine, including the fact that the funds were not sent with explicit and clear conditions stating that acceptance would discharge the plaintiff's right to accelerate and foreclose. And there was no meeting of the minds that could possibly exist when appellee was told unambiguously that the plaintiff reserved all rights and that the acceleration foreclosure rights were preserved and that the funds were only being accepted in settlement of the district court forfeiture action. And I won't go through the documentation of that we attach and talk about in our briefing. Similarly, there is no clear and unambiguous act by the plaintiff that constitute waiver of the right to accelerate and foreclose. We cite to the court the Minchella versus Fredericks case, published opinion of the Court of Appeals. It talks about waiver simply not applying in the case of foreclosure once that notice has been sent. That vests your rights. There can't be any waiver after that. So unless the panel has questions, which I'm glad to answer, we rely on our brief and would ask the court to reverse and to direct judgment in favor of the plaintiff.
Any questions? Any questions? All right, thank you very much, Counselor.
Thank you
This
so
matter
much.
is submitted. Turning to case number 21. Docket number 374477-D. Suman Chandra M. Patel, MD versus Corwell Health. Each side has 30 minutes. Good morning.
Yeah, Dr. Chandra Patel.
Counselor, how much time would you like to reserve for rebuttal?
5 minutes, Your Honor.
Second.
This is an appeal from a dismissal down below, as you know, granted in trial court granted summary disposition on Dr. Patel's claims. Also denied a motion for extending discovery and to allow additional depositions. The two main issues on appeal are, did the court err in granting the motion for summary in light of the evidence presented before her? And secondly, did the court err in refusing to grant new counsel additional time for discovery to depose witnesses? I'll start with the motion to compel first, because that leads into the second argument on the motion for summary. After discovery closed, Dr. Patel retained new counsel, Mr. Jablonski, and he immediately came in due to counsel's health and filed a motion to compel discovery responses, which were overdue after the discovery cutoff. And he also asked for additional time to depose certain witnesses. Former counsel, Mr. Rourke, had not done that at that point in time, and as new counsel, that's certainly not unusual. The trial court denied that motion in its entirety and did not extend discovery. And in so doing, the court, in the transcript, what the judge said is, look, this motion is untimely. It is after discovery has closed. And that is directly contrary, Your Honors, to the court rules on motions to extend discovery, in particular MCR 2.301B4, which says that you can file a motion to extend discovery anytime, even after the cutoff.
What do you have to show after the cutoff?
I'm sorry, Your Honor.
What do you have to show to get such motion granted?
You're gonna have you're gonna have to show a lack of prejudice to the other side, and the discovery, stands. Typically, the discovery is going to stand some likelihood of disclosing information that's.
You have to show any kind of good cause for the delay.
I don't believe a good cause in and of itself is required under the court rule, Your Honor.
An explanation.
It certainly helps to have that. And in this case, there was good cause. That good cause would be Mr. Rourke's health. It was not in, as counsel's pointed out, it was not in the motion to compel and extend discovery that he filed, but it was addressed on the record that Mr. Rourke had some health concerns. And that was.
Oh, but if I recall correctly, all it said was he was stepping back for a health reason, but he stayed on the file. He never, I guess the bigger issue I have is that this case was filed in September. The scheduling order was entered in December, and there was a May 1st-ish cutoff for discovery. And the first request for documents, production of documents, was not submitted until the middle of April. That is an absurd amount of time to wait to basically begin discovery.
Your Honor, I would not disagree that had I been the counsel on the case down below, which I was not, discovery is done.
So the appellate counsel always has that advantage.
I always
wasn't
have
the person
to
who
say
did that.
That's right, Your Honor. And I'm not faulting counsel for their trial strategy, but certainly at the time that when Mr. Rourke was in charge, there was little discovery that was done. I have to concede that based on the record as it is. However, when new counsel came in and indicated to the judge that there has been a health concern, and that in effect that was what was requiring new counsel, and new counsel had different ideas about what should or should not have been done, and needed additional information and made the request. But there wasn't a record made of what was the health issue, or is it cancer, is it this, is it that? And that, my experience is that's not typically done on the record anyway. Courts are.
So
attorneys are officers of court. Sorry.
But we're looking at this as an abuse of discretion, correct?
Yes.
How do we find, even if one of us, if we were the trial judge, might have extended discovery, how do we find that this was actually an abuse of discretion?
Your Honor, I think the trial court statement that this motion is untimely under the court rules, when that was not the case, Your Honor, that was the court making a proclamation that the court rules are barring this because you did in fact wait until after the close of discovery and not until August. But I will stress that the discovery responses that preceded that motion were not served until July. So as far as an excuse for not having the motion to compel in, my understanding is there were no answers to compel at the point in time prior to Mr. Jablonski coming in. Does that answer the question, Your Honor? Okay, so I do think the court abused the discretion. There was no, at the time, there was no motion for summary disposition pending. Discovery had just closed at the end of May. This is August 1, when the motion was filed. Discovery responses were not served until July. So it was certainly pretty immediate after receipt of the discovery responses from the defendant that motion to compel was filed by new counsel. And immediately upon him entering appearance.
When did new counsel come in?
It was August 1, Your Honor, and that was the appearance date as well as the motion date.
And was new counsel, I forget, I apologize. Is new counsel separate firm or same firm?
Your Honor, they were separate firms. My understanding is Mr. Ruark had his own firm, but at some point in time, I believe, and they shouldn't speculate, but I thought that Mr. Ruark did eventually have some affiliation with Mr. Jablonski's firm, O'Reilly Rancilio. At some point in time, I don't know when.
Okay.
And I can't say for a fact, but that seems to be my recollection that there wasn't before, but afterwards there may have been.
Okay.
But I go back to the same argument, Your Honor, and that is that, that there's no prejudice to the defendant. There was no motion for summary that was pending. It was shortly after discovery had closed, albeit after discovery. And what Dr. Patel wanted and his counsel wanted was to depose individuals who would later file affidavits in support of the motion for summary. And that certainly left the response flat-footed as far as being able to rebut those, because there was no ability to depose those people before Mr. Jablonski came in. So first argument is, I think the court abused its discretion and that prejudiced Dr. Patel in not being able to depose these individuals and get information from them that could have been used to better rebut, more than he already did, the motion for summary that was eventually filed later. Second argument is the motion for summary disposition of the claims. And in large part, if you were to boil down the issues to one, it is Corwell claimed that you're applying for recredentialing at our hospital, where Dr. Patel has been credentialed and admitted for 30 years. I don't think that there's any question about Dr. Patel's immense credentials. He's been a doctor for.
I think the only question is whether his application for credentialing was complete.
Exactly, Your Honor. And the issue on there is, did he actually have what's called a covering physician? So when you have.
I think the answer is no, right?
Well, the answer was yes. And that's where you look, if you look at Exhibit L, we have.
The answer was yes, but it became no.
It allegedly became no.
Now, what's the allegation that it was no? I mean, it seems like it was pretty clearly no. And then I think, you raised the issue of, well, was that pretextual? Did they force him to? But I think it's unambiguous that there was no covering physician.
Well, so there was a covering physician, another Dr. Patel, unrelated to Chandra Patel. Dr. Patel did indicate that yes, he would cover. He sent an email that was relayed back to Dr. Patel indicating that, hey, your application is now complete. We've got it and we're sending it on. So at one point in time, that application was complete. And once the application is complete, the hospital's bylaws require a decision on it. Now,
It became incomplete pretty quickly.
That is certainly what the affidavits presented down below from Dr. Patel and the covering Dr. Patel, if you will, from him and the employees at Corwell. They said, well, Dr. Patel eventually withdrew and said, I can no longer act as this doctor's covering physician. Dr. Patel was not informed of that. He kept thinking his application was complete.
But didn't they send him an email indicating his application was
They allege
incomplete?
that they did, but there's nothing in the record showing that Dr. Patel ever got that. And in his deposition, he is unsure of ever being told my application is not complete. What he saw.
Did he say that he did not receive the email?
I do not recall him saying that directly.
Okay. I think there's at least evidence in the record that the email was sent, and your client doesn't have any ground for disputing that he received it. He just doesn't recall, if I remember right.
He does not have any recollection of ever receiving that email or ever being told that your application is incomplete. And if you look at, for example.
But I want to be clear on this.
Yep.
In his deposition, did he say, I did not receive that?
He has no recollection of receiving
Okay,
that.
well, I
email.
mean, then he just doesn't know. And I'm not sure that I don't think his answer calls into question whether the email was sent. I mean, the record seems pretty clear that the email was sent. Whether he received it, whether it went into junk, into a junk folder, who knows? But that would be more on him than on the sender.
That would if you look in the record, Your Honor, there is an exhibit, I believe it is B to my brief, is a letter from Corwell, a physical formal letter that said, Dr. Patel, we've received your application. It is incomplete. And therefore, we need more information, or we'll put it on hiatus, close this. There was no such letter sent afterwards, a formal letter as had been done in the past with Corwell.
Has your
Patel's
client
position is-
obtained a new covering physician?
I'm sorry?
Has your client obtained a new covering physician and reapplied?
He had not obtained a covering position, to the best of my understanding, at
Today?
any time. As
So
of today,
he still hasn't obtained a covering position and reapplied. So
I'm not
his-
aware of there being a pending application for him to do that for, Your Honor.
Okay. And in their briefing, Corwell says, get a covering physician, reapply, and we'll talk to you then.
Yes,
Okay.
that was in effect, Your Honor. So again, going back to the motion for summary, our position is we put in evidence that the application was in fact complete, that the allegation that it's not is pretextual or erroneous, at least in our opinion. And he's put in evidence of various of the doctors at the hospital who made age-related remarks in past credentialing for him when he had interviews with them. We think
But doesn't he minimize those remarks himself?
sorry?
Doesn't he minimize those remarks himself in his testimony?
I wouldn't say minimize is the right word, no, and the remarks are what they are. In fact, he sent an email as part of his credentialing process reminding Corwell that people have made these age-related remarks with respect to me and my application. And so he at all times thought that age was a factor in this, and that there was people that did not want him there. And then rather than taking up his application, even after it was complete and before the other Dr. Patel withdrew, just shelving.
Weren't some of the, I mean, the remarks were made years before the application, correct? Several years.
Well, one was made approximately a year
18,
before,
19.
and another was 22, if I recall the date correctly.
So 18 and 22.
I believe that's right, Your Honor.
I mean, reading the comments in context, they appear to be, you've had this great career. Are you going to ever go enjoy some golf and, do something like that? It was more of at least the way one way to read them would be that they were just inquiring that haven't you earned an awesome retirement? Not you're too old to do this job.
I think that is an interpretation, Your Honor, that would be an issue of fact. What was meant by that? Dr. Patel certainly took it as related to my age, and certainly went forward with that, thinking that his present application, given these prior statements and the fact that he's been credentialed there for decades, he obtained credentialing at a different hospital while his other application at Corwell was pending. In his view, those were discriminatory. And I think that that's more of a factual issue, Your Honor. And if you look at.
I have a question about the individuals who made the age comments. Are they members of the credentialing committee? I know they have very important positions, so I'm not denying their decision-making authority, but with respect to the specific process, are they members of the credentialing committee?
They were part of his prior, as I understand, part of his prior interview process. These were the people that he was involved in. Were they part of the present credentialing application? I believe the affidavits from these doctors said no in full candor. So back to the second argument, I think that the court erred in at least not looking at the evidence that he did present in a light most favorable, and certainly giving him the benefit of the doubt that maybe there is something to what Dr. Patel is claiming, and that his interpretation of these statements was in fact right.
The comments, I think you're correct that they could be read in different ways. I just think the biggest problem you have is the fact that even if the application was complete for a period of time, it became incomplete with the withdrawal of that covering position. And that's a big problem, I think, for you.
And there again, I
For
think
your
that,
client.
I believe that is a factual issue about the completeness of the application.
May I address that actually?
Oh,
You
yeah.
indicated there was a letter, so we know that there's an email that's sent, although he doesn't recall receiving it. In the June 10th, 2022 letter, it indicates, thank you for applying to BOMA. Wayne's medical staff, as your credentialing coordinator has made you aware, your application is currently incomplete. And it talks about the covering physician in that letter as well. And so at least this letter seems to indicate that they're Not only is there a letter that's getting sent to a physical address for Dr. Patel, but it appears to be referencing a conversation as well. And so is he still indicating that he just didn't know it was incomplete?
Your Honor, I think you're looking at my Exhibit B, the June 10, 2022 letter.
Yes.
So that is a letter from 2022. The actual at beginning of 2023 and the end of 2022 is when the other Dr. Patel came in and said, I will cover. So this is 6 months prior to that.
Okay.
My point with this letter, Your Honor, is that this letter is from Beaumont. It's on its letterhead, and it is formally advising Dr. Patel that your application's incomplete. It's sent by certified mail. They're making sure that this got to him. Coral's current position is we sent an email and we told you it wasn't, and that is enough. Albeit Dr. Patel denies getting the email and has no recollection of it, that it's a difference in procedure. And
Are there other emails in the record? I mean, was communication by email between the parties a regular practice?
there was a fair amount of communication between the parties by email, Your Honor.
Okay, so I mean, Corwell may at some point have said, we're doing everything by email, and so we're going to alert your client about the withdrawal of the other Dr. Patel as a covering physician. And I get that your client says he doesn't recall reading that, but I guess I don't see a don't recall as helping your client very much, because the record is otherwise unambiguous that an email was sent and it had that information in it.
Well, that is certainly the Corwell's position. Yeah.
Okay.
Dr. Patel, as I said, denies having any knowledge of getting that email, denies ever being told your application wasn't complete or that the doctor had withdrawn. And, as a result, was waiting for a decision on his application. He was waiting patiently. When it didn't happen, the lawsuit eventually followed. Okay. Your Honor, I know your honors. I know that you read the briefs. Unless the court has anything else specific, I'm happy to stand on my submissions.
Thank you very much, Counsel. You have plenty of time for rebuttal.
Hey, good morning, and pleased court. Ben Jeffers on behalf of Cora Health. I was also defense counsel in the proceedings below. Appreciate Mr. Anderson's comments this morning, and I appreciate his role as appellate counsel and maybe not having perfect recall of everything that would have happened down below if he had participated. And so I appreciate that. But there's a theme here from plaintiffs, which is we really don't have enough of a record. And that's why we needed a motion to reopen discovery. And that's why it was inappropriate to grant the motion for summary disposition, because there's not a record. That's just not true. While they may not have done a lot of discovery, Cora Health was very diligent. Discovery. We built a record. 2 days of deposition of the plaintiff. We have discovery documents. We have written responses, 7 affidavits.
Do you recall when you sent out your request for production of documents?
We had 3. And we would have started, I believe, in December right away. And frankly, at each time that we sent, they were late and we needed stipulated orders to compel.
Am I correct that their first request for production of documents was around April 10,
Right.
11, 12, something like that?
Yeah, it was less than 30 days before the cutoff of discovery. We opted to respond. And it was in that same email, I believe it was April 12th, 2024, where he said, here's our first discovery responses. And then I won't be taking any depositions. Okay. So trial counsel at that time made a tactical decision not to take any depositions. We had already submitted witness list and amended witness list. Every person that signed an affidavit that was relied on by the trial court had been on the exhibit list or a witness list. Every document we submitted to the trial court had been produced in discovery. The record that the trial court relied on that we helped build was known to them all along.
So, but if, let's say the first, if I do recall correctly, April 12, their first document production, request for production of documents. But I don't think you responded until July.
That's correct.
What took so long?
Right. It was
Especially if all of this record had already been built up by you.
Yeah. Because it was the first and only request, and at the end, rather than object on the basis that they were untimely, we worked with Mr. Rourke. I said, we will respond to all of this, but I'm going to need more than 30 days. And he agreed. So that was an agreement when we did it. The disconnect on the motion, I do want to address this. We produced the written responses via email, PDFs, and then we had a hyperlink in the email with a folder to all the documents we were producing. We send that email over and I get this fiery in July when we responded, right? So we produced our documents at the same time. I get this response, you haven't produced a single document. It was back and forth. I called them a couple times. It's like, hey, there's just a disconnect here. So when they filed a motion to compel, there was nothing to compel. We had produced everything. And the trial court realized that. She asked a lot of questions and realized, oh, this was at best just a misunderstanding about what we had produced. They were also asking for things that
Was there any
exist.
question of whether the hyperlinks worked?
No. And they ultimately acknowledged that they got it. So that was just a disconnect. They filed the motion to compel and to reopen discovery on April 1st. They did not even request a hearing at that time. You got
August 1st?
on August 1st, right?
You said April 1st.
I apologize. Thank you, Your Honor. August 1st, file the motion and appear. Okay. So we're talking about diligence here. You've got to file a precipice and a notice of hearing, whether it's a week or 2 weeks or whatever. They didn't file anything until September, right? Meaning they didn't even ask for this important motion to be heard. The following week, we filed our motion for summary disposition, timely. The parties proceeded to case evaluation, which Mr. Roark, the one with the, I guess the health issue, and I don't mean to make light of that, but there's just no record of it. He handled case evaluation. And then they opted to have this motion to compel and to reopen discovery heard in September. So by the time that the court heard this motion, yes, there was a motion for summary pending. It had been many, many months since discovery closed. It was clear that we had produced everything. It was clear what we were relying on. So she didn't need to make specific findings of prejudice. She was very familiar with the record. And in fact, when she denied the motion and said this is untimely, the next statement in the record is she said, they've already filed a motion for summary. This is ready. She was aware. She was aware. And here's the big thing that hasn't even been discussed yet. No amount of discovery, no deposition is going to change the undisputed fact that the covering agreement was withdrawn. And that's not an allegation or a maybe. It's very clear on the record. We have in our exhibit, it's 9. It's an email from the other Dr. Patel to Vivian at Corwell. I will not, capitalize not, be able to cover Dr. Saman Patel for patient care at Beaumont Wayne now and in the future. Thank you. We have affidavits from the credentialing staff and the others articulating exactly what happened. So it is undisputed that he had a covering agreement for a couple month period of time, then it was withdrawn. Once it's withdrawn, there's nothing that Corwell can do. Credential.
Was there a letter sent like the one that was sent in June, a formal letter as opposed to an email?
I don't believe so. I don't believe so.
Is there some reason why? I mean, it seems like in June, the lack of a complete application was a pretty formal issue that required a fairly formal notice.
Mhm.
And then when the application became incomplete again, it just seems odd that it also didn't trigger another very formal notice.
Right. Understood.
Is there an explanation for that?
Other than no good deed goes unpunished, I think that first letter, Your Honor, wasn't in fact required or necessary. There were actually a lot of things that he had. It wasn't just the lack of covering agreement. There were a bunch of things. And I think that at that time, the hospital just wanted to make clear all the things that were missing. We do in the affidavit, it's either from Ms. Powell or Ms. Radomski, I apologize, I can't remember, indicated yes, communicated with him and let him know that it was missing. But I'd like to address that for a minute. Let's pretend for a moment that Corwell didn't tell him. Okay. His lack of awareness of when the covering agreement was withdrawn isn't probative of whether he can make a prima facie case on age discrimination. We know what happened, right? We know from the undisputed record that the covering agreement was withdrawn by the physician. We have an affidavit from him. He said, I did it on my own volition. No one pressured me to do this. You have everyone else involved that said, once we got that, we couldn't move forward. And they expressly deny that age had anything to do with it.
I think
That's
the issue
record.
is if no notice would be expected. And if there was no notice, that might raise a question of pretext. I think that's at least in my mind, that would be the issue.
Right. And I will address that. There's a temporal issue because that would be after. You've got to look at, well, what did the hospital do or not do? The hospital merely reacted to an independent physician that they don't employ or control withdrawing this covering agreement. There's no pretext there. That's not the hospital's actions. So the hospital can't move him forward. Is there a dispute about when they told him that, or should they've done more? That doesn't raise an inference of age discrimination. We can speculate all day long about what it meant or didn't mean. But what we know is that there's denials in the record, denials that age had anything to do with any of this. And to the question that you asked, Judge Young, when Dr. Patel, the plaintiff appellant, I guess fully realized that, what did he do? Nothing. He didn't submit a covering agreement. To this day, he hasn't done it. He could have done that at any point in the litigation. And Corewell Health would have said, we will evaluate your application straight up. And let me end with this. We're talking about this almost as if it's a check the box exercise. Hey, I've got a checklist of things I need to do. I want to make sure the court is aware a covering agreement is a safety issue. When you have an independent physician receive credentials, what that means, it's a permission slip to admit and treat patients at a hospital. You're not employed by the hospital, right? You're allowed to take a patient there and do rounds and see them. If there's a problem with that patient, the nurses or staff, they're going to first try to call the attending, the admitting physician. If they can't get a hold of that person, they need someone else to call. That's what a covering agreement is. So it's a requirement all the way through the beginning of your application and while you're credentialed. Dr. Patel in his deposition admitted this was a safety issue, so there's no dispute there. So the point here is, although his application didn't get off the ground, it could have gone to any step. You know, you go from department chair, that's Dr. Shaw. He never considered this on the merits because, you know, the agreement was withdrawn. Then it goes to credentials. They didn't consider this either. Then what's called the MEC, the Medical Executive Committee. That's the main committee of physician leaders at a hospital. Then ultimately the board. Under the public health code, it's the board that has ultimate say over credentialing of physicians. It wouldn't have mattered when that covering agreement was withdrawn. It could have been complete at step 1, complete at step 2, 3, and 4. If it had gotten to the board and the day before the board meeting, someone withdrew that covering agreement, he can't move forward.
Is there any question in the record that those two people who talked with the plaintiff before this application process started made age-related remarks?
Is there a dispute? They dispute it, yes, but I would recognize that that's a disputed fact. The statements were made in 2017 and 2020. There's actually a typo in our brief. We said 22, that's wrong. But this comes right from their complaint. You don't have to take my word for it. It's paragraphs 86 and 87 of the complaint. Dr. Patel alleges in 2017, Dr. Shaw said this, and in 2020, I believe it's Dr. Jane said something else.
So those two doctors dispute that they ever made those age-related remarks.
They weren't deposed, Your Honor, but in their affidavits, they deny that they took any action on the basis of.
I didn't ask about action. I asked, did they dispute that they made age-related remarks?
And I'm just being careful because they weren't deposed. I don't know that precise question was asked of them in the record.
In the affidavit, did they say we did not make those remarks?
Great question. I don't recall. I don't think that was the focus of the affidavits.
Okay.
Okay.
That would seem to be a logical focus of the affidavits. I mean, because they were ambiguous and you could certainly read them in a nefarious light. And it would seem to be an obvious point to make. If they didn't say it, that would, I would assume, be like paragraph 2 or 3
Right.
of the affidavit.
Right. Understood. Let me say this.
If they did say those statements, those were pretty dumb statements to make, I think is my point.
Yeah, understood. But here's the thing, the trial court didn't rely on an interpretation of those statements
I know.
in making her decision, right? So she relied on the fact that due to the covering agreement, lack of covering agreement, he wasn't qualified. But I do want to assure you this. Even if you have statements, let's assume they were made, Your Honor, in 2017, 5 years before and 3 years before. Dr. Jane, who allegedly said one of these statements, in his affidavit, he said, I wasn't involved in credentialing whatsoever. So you have a straight comment by someone who was never in the room. It's wholly unrelated. There's no tether. There's no link. Dr. Shaw would have been involved in credentialing. He was the department chair, but he took no action. And he said in his affidavit, I took no action because it never got to his desk because the covering was drawn. So there's no link between these statements, even if they were made exactly the way plaintiff alleges. No connection whatsoever. So, I will end with this. I've already spoken more than I intended to, but it's worthwhile for the court to know that Dr. Patel's deposition was remarkable in that he ultimately acknowledged that at the time that I deposed him, this case was no longer about the application. I asked him, what's your goal? Is it to have Corwell consider your application? Not at this time. This is right in our brief. We cite this right in our brief. What is your goal? I want to seek justice against certain individuals. Who's that? Dr. Jane and Dr. Shaw. Well, and I said, sir, we're here talking about your credentialing application and you have complaints about Dr. Jane. Do you have any evidence to connect those two things? No, I do not.
Well, I don't get the point you're making, because if he was discriminated against, it's entirely rational for someone to say, I don't want to actually work there now, but I do want justice. So I don't see how his remark is inconsistent with his lawsuit.
What he was saying is he has no evidence that the person he now blames, Dr. Jane, had anything to do with his
But
credentialing.
Shaw was involved in it. So I just.
Okay, fair enough. If there any other questions? All right, thank you.
Thank you very much, Counselor. Rebuttal?
Question from the court indicates the court is well aware of the issues in this case, so I'll yield my rebuttal. Thank you.
All right, this matter will be submitted. We are going to take a short break and we'll be back out to handle the remaining matters on the docket at the 10 a.m. Thank you.
Please sit down.
Good morning again, everyone. For those of you who were here earlier, I apologize. I am going to be repeating some of the comments I made earlier. Again, welcome to the Michigan Court of Appeals. This is the first day of case call for panel 2 of the court's May 2026 session. Again, my name is Miriam Bazzi, and I'm joined here today by Judges Mark Boonstra and Judge Brock Swartzel. We understand that these cases are important to the litigants and counsel, as I want to assure you that they are important to us as well. We have been diligently working on these matters. We've had the benefit of your briefing as well as the work of our research division and chamber staff. We are familiar with the relevant facts and pertinent law, and so we ask you to focus oral argument today on your most salient points, why you should prevail, and what is critical for us to understand. Finally, we are hearing matters involving sexual assault victims, personal protection orders, and children. Because these proceedings are recorded, we ask you to please use their initials rather than the actual name of any victim, child, or other vulnerable individual in those cases. With that, we are going to move on to the next matter on our docket. That would be item number 1, docket number 375745, People of Michigan versus Eric Lamont King Pierce Jr. And it looks like the only endorsed individual for oral argument is defense counsel. Good morning.
Morning, Your Honors. David Herskovic appearing on behalf of Eric Lamont King Price, defendant appellant in this matter. A little case history. This case, we had filed an application for leave to appeal to this honorable court. It was denied. We therefore appealed to the Michigan Supreme Court, which remanded it back to the court, asking the court to handle the case in expedited fashion, which it has. So we thank you for that. Brother counsel is not here because they filed a brief late, but we still plan to respond to what they put in their brief. The primary issue here is OV-14. And OV-14 deals with multiple offender situations. And it says, in order to assess 10 points under OV-14, the prosecution must establish that the defendant was a leader in a multiple offender situation. Put plainly, there was one individual arrested, one individual charged, and there was one individual convicted. This was not a multiple offender situation.
What about the person who sold him the credit cards or credit card numbers? He wasn't charged maybe in this transaction, but he was an offender in some sense, wasn't he?
Even if he can be assessed as a second offender in this situation, they still would need to show that Mr. King Price was a leader within that group. And as it regards that individual, because the court below, it gave two theories as to how it possibly could have been a multiple offender situation and a leader. And in that instance, under that theory, what did the anonymous individual gain from Mr. King Price using credit? What did he gain that weekend from Mr. King Price using credit cards that were not his to have a weekend with his girlfriend and his kids? There's no, even if we are to agree that there is a multiple offender situation, there's no evidence of any leadership on Mr. King Price's part in order to assess the 10 points. Same thing would be true under the lower court's other theory that his girlfriend was another offender in here. There is no indication anywhere that Mr. King Price was the leader in this. It's just as easy to show that his girlfriend was the one who instructed him to do all this. There's just no.
Is there any evidence that she instructed him to do this?
There's no evidence of that, nor is there any evidence that he was a leader in this either. The fact of the matter is, it's a single offender situation. She wasn't charged. She wasn't arrested. The only person arrested in this instance in that hotel room was Mr. King Price. She was present.
Let me ask you something. Was there any statement taken from her? Was there any type of statements about the defendant mentioned her? I didn't see it, but I want to make sure I didn't miss anything.
The only reason she is even involved within the parameters of this case is because she's mentioned within the PSI that he owes child support to her.
But beyond that, there's no mention or conversation. No officer spoke with her at the scene. There are no reports at all.
No, not to the best of my recollection, having gone through the file, no.
Because the fact that she wasn't charged alone doesn't necessarily not make her a co-conspirator, but.
I would agree with that, yes.
Okay.
You are absolutely correct in that, Your Honor. Just because she wasn't arrested doesn't mean she couldn't possibly be a second offender in here, but there's just no evidence of any of her involvement whatsoever. And I understand, Judge Swarthout, your question regarding, was there evidence of her? There's just no evidence of anything. If the court below and prosecution is making assumptions, based on alleged conduct, it could just as easily go the other side,
There is evidence in the record, though, that he purchased these credit cards from someone, correct?
Yeah, we don't deny that whatsoever. He pled guilty to this. He is guilty of he admitted to buying the credit cards. He admitted to going up to Boyne and having a fun weekend, which we all wish we could do legally. but he did it illegally. There is no doubt about that. The only question we're here on is whether this was a multiple offender situation and whether he constitutes a leader in this. This isn't a situation like in other cases where I've had where you have two guys robbing somebody, you don't know, and one of them points a gun and says, do this. That's not here. You know, in fact, in the PSI, the only reference of the actual actions of other people being present when he's doing it is having his kids with him when he's in the store purchasing them items up at point. Again, the kids obviously are not charged. They're not co-conspirators. You know, there's no allegation of any of that here. It is our feeling that the court below views their discretion in assessing the points. We would ask the court here to see where we are coming from, find that the 10 points was scored incorrectly, and therefore order resentencing because the 10 points would change his scoring guidelines. And under Francisco, that would require resentencing in this matter.
Any other questions? Thank you very much, Counselor.
Thank you.
This
and
item will be submitted.
a happy Cinco de Mayo to the court.
Yes.
Thank you.
Have a good day.
Thank you.
All right, calling item number 2, docket number 363-752-D, People of the State of Michigan versus Ronald Antoine Gray. And we have defense counsel endorsed. You have 15 minutes.
Morning, Lee Somerville on behalf of Mr. Gray. This is his appeal from his jury trial. He was convicted of second-degree murder, 2 counts of assault with intent to do great bodily harm, felon in possession, and 4 felony firearms. Raised 4 issues: ineffective assistance of counsel, which also encompasses some of the other issues, jury instruction issues, the in-court identification of Mr. Gray by someone who couldn't identify him prior to trial, and the cumulative effect of these errors. And I think that the jury instruction issue is, to me, the most egregious. There was no request for any manslaughter instructions. At the Ginther hearing, the attorney said that he was concerned that juries in murder trials want to compromise. But Mr. Gray was charged with first-degree murder. Of course, they had to be instructed on second-degree murder, which ended up being the conviction. So, you know, if that was a compromise, it certainly would have been better for Mr. Gray to have another choice. And it certainly was prejudicial to him because on the pre-sentence report, the guidelines are scored for murder 2 at 365 to 600, but actually it's 365 to 1200 because he's habitual fourth. The manslaughter on the C grid would have been 62 to 228 as habitual fourth. So, you know, he's certainly prejudiced by not having that opportunity to have them consider a manslaughter charge as well. The other, excuse me, issues with instructions are that the court offered an accident instruction. And the counsel refused it. At the Ginther hearing, he said it would have diminished his credibility, which doesn't make any sense to me because attorneys don't give the instructions. They come from the court and they apply to both sides of the argument.
Is
But
the I'm sorry, no, go ahead.
Well, doesn't he have to argue all of the jury instructions and all the elements of all the different options before the jury? And the defendant testified and kind of talks his way out of the accident at some point, but doesn't he also testify that it undermines the theory of self-defense?
Yeah, he said that, but I don't see, I thought he said that in connection with, well, he said that in connection with everything. He also said that in connection with the manslaughter issue. He doesn't have to argue everything. But it's a set of instructions that in most cases now, the jury takes back with them so they can refer to during their deliberations.
But he would have to give them context of what the jury instructions are. And so if the theory at trial is this is self-defense and the defendant testifies that he acted in self-defense, where's the accident?
Well, the defendant's testimony was that he didn't know if he hit anything when he shot.
But
Um,
he testified he was shooting in self-defense.
Right.
I mean, whether his aim was very good, but
That's where the accident would come in.
it was clear that he was relying on self-defense.
Yes, it was.
Okay.
But first of all, the defendant's allowed to argue multiple conflicting theories if they want.
Well,
But
I
he
guess my
does-
point is with self-defense, it seems logical that if you're trying to defend yourself, you're not just, willy-nilly shooting in the air. You're actually trying to stop the person who's attacking you. And that seems inconsistent with accident. Right? I mean, I guess explain to me how you can have the defendant who testified very clearly that this was self-defense and how that would also be consistent with accident other than, the point you just made. Is
Or
there,
didn't mean to kill him, just meant to stop him, didn't mean to hit the other two people. Those could be accidents.
Didn't he testify that, didn't he acknowledge that he aimed the gun and shooting wasn't by mistake? It was, he pulled the trigger intending to shoot,
Yes.
didn't he? So how does
But
that
he didn't-
equate either
he
to
didn't-
accident or to voluntary manslaughter?
He didn't testify that he wanted to kill. I'm gonna call him Mo Green because that just sticks out in my head. He didn't testify that he wanted to kill Mo Green. He was just trying to get out, basically. And also his testimony was that he didn't bring the gun, that Mo Green had the gun and they fought over it and some shots went off when it was still in Mo Green's hand. Excuse me. So I thought that there were a lot of things that accident could have applied to, depending on what the jury believed as far as, the different testimonies. With respect to being focused on self-defense, the attorney then refused the felony firearm self-defense instruction, saying he thought that the other self-defense instruction covered it. But that self-defense instruction was given with the names of the other offenses, the first-degree murder, the assault with intent to murder, not the felony firearm. So that doesn't make a lot of sense.
isn't that harmless error at some point though, or there's a lack of prejudice because he was found guilty of a felony and there's no question that there was a firearm involved?
Well, maybe, but it's hard to know if the jury's not instructed on everything, what their decision would have been had they had other options. The one thing he did object to was the inclusion of the duty to retreat in the self-defense instruction, which, probably shouldn't have been given based upon the testimony that this was a sudden attack by Mr. Mo Green against him as he was trying to walk out.
Doesn't he testify that he could have walked out, but he didn't want to turn his back to what he perceived as the threat, which is why he stayed and shot? And ultimately, that instruction also indicates that a person, if you don't have to retreat, if you believe that you can't do so safely. And so they were instructed as to that. And that's ultimately what he testified to. He didn't believe that he could retreat safely. So how does that hurt your client?
Well, the objection was after the jury was instructed. So that was the error that I was going after. The other ineffective assistance of counsel, the not getting an expert for scene reconstruction. There were some testimony that an old bullet was found in the bedroom and there were holes in the bedroom wall, like some of the shots came from there. And part of Mr. Gray's testimony was that he did not bring this gun, that he took it from Mo Green. And counsel did acknowledge at the Ginther hearing that he was asked about a scene reconstruction person, and he never talked to anyone about that. And he didn't follow up on the old bullet to see if they compared it to the other bullets, which, you know, would have supported part of Mr. Gray's testimony that he did not bring that gun to the house. And then not objecting to I think he should have objected to the question when the prosecutor asked Miss McKinney to identify Mr. Gray when she had not been able to identify him prior to trial. So that's that. And then I did raise the jury instructions as a standalone issue, but I realize that there's only that one objection. So that's why it has to come in under ineffective assistance of counsel. And I don't have anything else unless you have any other questions.
No.
Thank you very much, Counselor.
Thank you.
This matter has been submitted. Moving on to case number, item number 3, docket number 371879-D, People of the State of Michigan versus Keith Williams. We have both sides endorsed for oral argument. Do we have both counselors here? No? All right. Then, oh, I'm sorry. Are you on this case? Oh, my apologies,
Yeah.
Counselor.
That's why I was hanging around.
All right. You may proceed. How much time would you like for rebuttal?
I'm probably not going to take up the whole time, but 5 minutes.
All right.
Lee Somerville on behalf of Keith Williams, which is why I wanted to call the victim in the last one Mo Green, because they're very similar names. But Mr. Williams was convicted by jury of assault with intent to great bodily harm and felonious assault, 2 counts of felony firearms. Trial court denied my motion for a Ginther hearing, and this court denied a motion to remand, which was about the Ginther hearing and the issue that I added on double jeopardy. So I didn't have a chance to flesh those out in the trial court. The ineffective assistance of counsel, prosecutorial error, cumulative errors, and double jeopardy are basically what I have. Ineffective assistance of counsel. The counsel did not obtain the ring video of the event. The police didn't obtain it for some reason. The OIC's testimony was like, well, I assume that somebody asked about it since it was there on the building. But there, I did include an attachment that I included with my trial court motion that Ring has a default of retaining all the videos for 60 days unless you set it differently yourself. I don't know how to do that, but
Didn't the brother, however, testify that the camera wasn't positioned to capture the events here?
he testified to that, but then at the second hearing on the motion, somebody had finally given me the video of the fire. And it showed down to the street. And the Derek Williams' testimony was that he was putting the key in the door. He had made it to the porch, was putting the key on the door, and then he heard shots. So his testimony was that the camera was positioned to pick up people coming up the walk and onto the porch. So that's where he was. So he would have triggered it. And then it shows stuff behind you, even though those things by themselves might not have set it off. You know, and that's why the police often look at ring cameras, including ring cameras across the street, you know, or neighbors or whatever, because they do capture things besides where they're set to capture things, if it's behind there. And the video of the fire, my client, well, first of all, the trial counsel had said he had received that. He didn't give me anything. But some family member or friend of the family gave it to me, like, you know, at the last possible minute. So I provided a copy to the prosecutor in the court. And it does show, it shows like two surfaces intersecting that are like concrete looking. So I'm assuming that's either the side street and the street or the driveway in the street. But anyway, it does show a street. So based upon the testimony that my client's car was in front of the house in the street, it would have showed it. It would have showed like what he was doing. If, you know, if a gun was coming out of his car or if he was outside of his car. Also, it picked up sound. And that would have been important. I mean, spot shutters aren't, you know, aren't like right on point and always correct. They're, you know, kind of iffy. And they weren't even pointing to this address. It was like a couple houses down or something that they said the shots were coming from. And then the OIC said something to the effect that that could be because they were shooting away from the house, which would support my client's affidavit where he said that his brother was the one that shot. He didn't necessarily shoot at him, but just shot. Okay, he did not obtain the full text of the conversation with these text messages. And the prosecutor had made some comment about we don't dump every phone or something. But they also would have been on Mr. Williams' phone. And the judge at the preliminary hearing says, if you prepare an order, I'll get you an order to get that phone back. And 3 months later in the circuit court, he's still asking about text messages. So it seems to me that that order was not prepared and submitted. It certainly didn't come to me with a copy of the court file. So he had the opportunity to do that. A judge saying he would sign an order so he can get it, and he didn't do it, but he kept, you know, talking about it, how they needed him. Or he didn't object at trial or bring a motion in limine regarding the alleged 2021 shooting. And I thought this was particularly a problem because the prosecutor had brought a 404B motion about text messages, but they didn't include the allegation that my client shot at his brother in 2021, which the brother did acknowledge he didn't see him shooting at him. And then the trial counsel asked for lesser includeds on both counts. And he asked for the assault with intent to create bodily harm. He asked for aggravated assault and then assault or assault and battery. And the judge said he would give one lesser included for each count. And he was going to give the aggravated assault, but then they figured out that it's not really a lesser included, but he didn't give the assault then, assault or assault and battery. And I know that the prosecutor says assault and battery wouldn't have been appropriate, but they didn't object to it at the trial. And I think the touching can be to the person or something connected to the person. And the testimony of Derek Williams was that he was on the porch with his key in the door when he heard the shots, and then his house got shot. So that's something he was in contact with. So either one, assault or assault and battery, could have been a lesser included. And then finally, my client did not explain the value of the plea offer. He didn't understand that he would definitely get prison time. He was convicted of felony firearm. And I know the prosecutor says, well, he went to trial on a felony firearm before, but he was acquitted. So, when you're acquitted, probably you don't think about those penalties very much, or, you don't have to deal with him. You don't have to go to prison. So I don't think that shows that he understood he would definitely do that. Then I've also alleged prosecutorial error, offering the testimony from Miss McKinney, and cumulative error and the double jeopardy thing. And, I think that I just saw like the unpublished opinion with assault with intent to murder, and I really hadn't thought about McEwen. McEwen and Gardner were decided on the same day. And I just think that Wafer and Wafer, they were dealing with a second degree murder and an involuntary manslaughter for the same act. And they said that the phrase without malice is not an element. And it would be nugatory if it failed to prevent double punishment. That is, for the language to have any effect, it must prevent cumulative punishment. Otherwise, it would define neither the criminal conduct required to be proven by the prosecution nor the penalty for engaging in contact. And then I would point to, and I realize that, the Supreme Court has decided McEwen, but I really think that the dissent was right.
Isn't that a question for the Supreme Court, not us? I mean, even if we completely agree with you, you just acknowledge it's a dissent, and make the argument to the Supreme Court. I don't see the value in arguing it to us where we can't do a thing about it.
Well, I mean, I have seen some opinions saying, well, we're deciding this way because, but otherwise we would have decided this way. Well, anyway, Judge Clement goes into why the, relying on Wafer's analysis, that it is the felonious assault statute that controls, that prevents them both from being at the same, not charge, but conviction at the same time without violating double jeopardy, because the legislature specifically said, without intending to do great bodily harm or murder. I don't think it was in that order, but anyway, I think that is waiver and that dissent are probably the appropriate way to look at it. And I'm sure I got a couple minutes left for rebuttal.
Okay, thank you very much, Counselor.
Good morning, Your Honors. David Fox from the Wayne County Prosecutor's Office, appearing on behalf of the appellee, the people of the state of Michigan in this matter. Mostly just want to briefly focus on the defendant's claims of ineffective assistance, although I'm happy to answer questions from the court about any of the issues raised in defendant's brief. As it relates to the ring camera, my position is that the defendant has failed to establish the factual predicate of his claims. There's been no showing that there's any actual footage of the shooting that occurred. The clip that was submitted after the fact hasn't been authenticated. There's no showing where it came from, or that it is actually the defendant's or the victim's front porch.
Let's assume it was, given the fact that there wasn't a Ginther hearing. Let's just assume it was. Let's assume it was authenticated and it was from the victim's front door. What's your position then?
Well, when this court's looking at whether the defendant can establish prejudice, I don't think there's a reasonable probability that any footage of the actual shooting, assuming it does exist, but there's no evidence before this court to suggest that it does. Given the other evidence that was admitted at trial.
Is there any explanation of why? I mean, the ring camera footage would seem to be a natural source of evidence that you would want to preserve. I think we have 2 or 3 cases between today and tomorrow where ring camera footage has been very helpful or is useful in cases. Why is there any explanation of why that ring camera footage was not preserved here?
The officer in charge did ask the victim. I think he testified that he asked the victim about the ring camera, and he confirmed that there was never any ring camera footage available of this incident.
Did the victim give any explanation? I mean, there's a ring camera and there's at least some evidence that it was operational. Did the victim give any explanation of, I mean, is it just gone? Was it not operational? Did it not get retained for the default 60 days? Any explanation in the record?
There's no explanation as to that in the record. He did testify, as was mentioned previously, that it wasn't set up to actually show the shooting, that it only activated when people walked up to it. So the victim's testimony was that it wouldn't actually show the shooting.
Okay, so even if you could see the scene, it would not get activated simply by someone driving around on the road and maybe shooting.
Correct.
Okay.
Now, I'm not sure. I don't have a ring camera myself, but I would just note that this shooting did happen in the middle of the night, so it was dark outside. So I think any claim that it may have shown who the actual shooter was would be speculative at best. And even if we were to assume that there was ring camera footage available of the actual shooting, the other evidence, the shot spotter evidence, that there were 10 shots fired in front of the victim's home, and there were 2 bullet holes found in the window right next to where the victim was standing. I don't think that there's any reasonable probability that speculative ring camera footage would have supported the claim that the defendant raised in his affidavit, which was attached to his motion, which was that he didn't have a gun that night, that the victim was shooting in the air. I think in his affidavit, the defendant even acknowledged that the victim wasn't shooting at his house, but yet he fails to explain how the 2 bullet holes ended up in the victim's window.
Is there any question? Because there were some text messages purportedly sent by the defendant to the victim after the almost immediately after the shooting, or within an hour or 2 after the shooting. Is that correct?
Correct. I think it was even sooner than that. I think it was within minutes after the shooting.
Is there anything in the record to suggest that defendant did not send those text messages?
No. The victim testified that he received a call. He immediately recognized the defendant's voice. And then I think after that, he received the text messages from the defendant.
From the same number.
Correct.
And those text messages were rather
Rather
explicit.
correct. And I think it really spoke to the defendant's intent because he explicitly told the victim that he basically wanted him to die. So even if this court were to make a jump, which I think is not possible, to assume that there was ring camera available, which the defendant has not shown, I think that the other evidence in this case was very strong and there's no reasonable probability of a different outcome, even if there was a showing that defense counsel could have gotten this ring camera footage. As to this prior shooting, I believe that was highly relevant for several non-propensity purposes, and that it happened just a year and a half before this shooting at the same location between the same parties. I think it spoke to the defendant's intent in this case. And while prejudicial, as all evidence is, the trial court did give a jury instruction, which I believe cured any possible prejudice. And again, given the other evidence, the text messages, shot spotter reports, and the 2 bullet holes in the victim's window, I think any error in that regard was harmless. The defendant at no point suggests how he could have approached this differently if the prosecutor had included it in her 404B notice. As to the lesser included offense, I would just note that I think it's relevant when this court's determining whether the defendant was prejudiced, that the trial court did instruct on assault or assault and battery as related to the felonious assault charge. I realize those intent requirements are a little different between felonious assault and assault with intent to do great bodily harm, but the jury did not go for the assault and battery as it relates to the felonious assault. And by finding the defendant guilty of assault with intent to do great bodily harm, explicitly found that the defendant intended to harm the victim. So I think there's no reasonable probability that had the lesser included and given to the other charge that the jury would have gone for that. Nor does the defendant provide any evidence to support his claim that counsel didn't tell him about the penalty for felony firearm. I do think it's relevant that the defendant made a decision before this to proceed to trial on the very same charge. The trial court did tell the defendant that the felony firearm carried a flat 2-year sentence. And there's no evidence in the record that the defendant wanted to take a plea. Even on appeal in his own affidavit, the defendant continues to proclaim his innocence. So the defendant's claim there fails as well. As it relates to the prosecutorial misconduct claims, I think my brief adequately sets out why the trial court's instructions cured any error and the defendant wasn't prejudiced by the 3 leading questions the defendant complains of in his brief.
About the double jeopardy issue, and I think Ms. Somerville's good point that, you know, even though we're bound by what the Supreme Court said, if one or more of us disagreed, we could always write separately to hopefully prod the Supreme Court to change what's your position on. I mean, is the Supreme Court correct in its double jeopardy analysis?
I believe they were, Your Honor, because I think
So Justice Clement is absolutely wrong.
I wouldn't say that, but I think the court was clear that the assault with intent to do great bodily harm statute explicitly allows for multiple punishments for an assaultive act arising out of the same transaction. I think this court has to look to the plain language of the statute. That's what the Supreme Court did. I think it's bound by McEwen and it should follow that in this case. I don't have anything else that isn't otherwise better said in my brief, but I'd be happy to answer any other question.
Thank you very much, Counselor.
Thank you.
You have time for a rebuttal?
I don't have much, but I can't prove what's on the ring camera because nobody preserved it. Police always get the ring camera. Unless it's going to help the defendant. But, and counsel should have gotten it himself once he knew they didn't do it. With respect to the prior shootings, one sentence stood out to me because it sounds like it's describing propensity evidence in counsel's brief. Here, because the evidence of the prior shooting makes it more likely that defendant possessed a gun and fired gunshots at the victim than it would be without the evidence. You know, it's just describing propensity evidence. I had one more thing, but I forgot it. I'll just rely on the brief.
Thank you, Counselor.
Thank you.
This matter has been submitted. Moving on to item 4, docket number 374070-D, People of the State of Michigan versus Christopher Andrew, is it Canales? Canales. We have both sides endorsed for oral argument. You have 30 minutes. How much time would you like for rebuttal? 5. All right, you may proceed.
Thank you. Good morning. It's lovely to be here. Rachel Wolf on behalf of defendant appellant Christopher Canales, and may it please the court. We're here on an appeal from a resentencing hearing out of Wayne County. In our brief, we challenged the scoring of 2 offense variables, OB4 and OB14, as well as a general proportionality argument. I had noticed that the prosecution conceded the argument on OV4 that there are not facts on the record, and I just want to say that I do appreciate that candor very much. And so the only 2 issues, of course, are OV14 and proportionality. And I will keep it brief because I think we both wrote pretty good, pretty thorough briefs in this case. But it is my position that there are no facts on the record to support that the defendant was a leader in a multi-offender situation. I know we already talked about OV14 earlier this morning, so I won't go into.
Your client's the one in the back seat.
So this is a case where my client and the co-defendant approached the victim together on the street over some money, I believe, that was owed to a third party. And then they grabbed him, dragged him back to an apartment, and there was an assault that ensued inside the apartment. So there wasn't a vehicle involved.
Okay.
But they did drag him back there together. And there are no facts to suggest that he was sort of in charge of the situation. He acted with this co-defendant who was 9 or 10 years older than him. They both were asking this young man, the victim, where the money was before they grabbed him and dragged him together up into the apartment. And this assault occurred in front of 5 to 7 other individuals, one of whom was the lawful tenant of that apartment. And so the prosecutor has pointed out a couple of facts suggesting that my client was the only one who knew the victim. That's not true. The victim testified that he did not know the co-defendant, the one who he met with my client down on the street, but he said that he did know the individuals that were in the apartment,
Did the
including.
victims say that the defendant was the first one to start hitting him with the stick?
No, he did not say that. There is a statement in the record that the victim says they were both hitting him with a stick, and then the prosecutor asked, now who specifically was hitting you with a stick? And he once answers, well, yes, it was him. It was the defendant. But of course, the defendant, my client, was the only person there on trial. That's the person they were specifically asking about. I think it is possible, if you take that statement out of context, you could argue that there is some evidence to support what the trial court apparently decided was evidence to support the assessment of OV14, but we don't, and we haven't for over a decade, used the some evidence standard. We're looking at if there is a preponderance of evidence to support the fact that my client was the leader, meaning that he guided, showed the way, directed, conducted, controlled in some way the actions here. And there are no statements at all to suggest that he was guiding or controlling the actions of the co-defendant. There's nothing to show that he was the only one with a motive. In fact, the victim testified that he knew the third party who he owed money to. He knew why the defendant and co-defendant were there, and getting him and bringing him to this apartment.
Did the defendant tell the victim that he was not leaving until the defendant received the money?
I actually don't recall from the transcript which one of the co-defendants said that. I remember the victim.
Would it be
testifying.
relevant if it was your client who said that with respect to whether your client was a leader?
That he wasn't leaving the apartment? No, I don't think that shows any direction to the co-defendant or any of the other 5 to 7 individuals in that apartment. It is evidence
Did
that
your client tell the victim that if he didn't remain quiet, that he was going to kill him?
That is in the record.
Doesn't that suggest that your client was at least taking the lead and maybe not direct, whether he was directing the others or not, I don't know. But your client seems to be the one who was ordering the victim around, telling the victim what was going to happen to him if he didn't cooperate. Doesn't that suggest leadership?
My client was the one who was charged and went to trial. And so he is the one, obviously, that we have the most facts about. So that's just the nature of things. I'm not disputing that he participated in this offense or that he participated maybe even in a heightened way. But what he did not say was, hey, if this guy leaves the bathroom, kill him. That's a direction to another person, right? Him, after the assault had already occurred, after the victim is already in the bathroom, there's, like I said, 5 to 7 older people in this apartment with the defendant and the co-defendant still. The fact that he then says to the victim, if you leave this bathroom, I'll kill you, does not show
Is there any evidence in this record that some of those older, more experienced people in the room were the ones directing your client to do what your client did?
Not expressly. No, there's not. I think it is implicit that, the victim said he had been there before. He knew these individuals. He had been to that particular apartment to buy drugs before. But unfortunately, as to my knowledge, none of the individuals in the apartment was charged in connection to this case. So I don't actually know what happened to all of them. I just know that the co-defendant was equally talking about, hey, where is the money, acting in concert with the defendant. And in fact, the co-defendant is the one that gave him a phone and said, hey, you need to call your financial institution, give me some information about the money right now. So I wish that I had looked, and I didn't think about it until yesterday, to see if the court scored OV-14 for the co-defendant as well, because I think that there is more evidence that he was directing things, just because he also was acting on behalf of this third party who I would say is more likely to have been in control. And he's also older. And I know that the older co-defendant is frequently, said, oh, you're the leader because you're the older individual. You're acting as part of this team. So I wonder, and I wish I had looked, perhaps opposing counsel knows, but I don't, unfortunately.
What's our standard of review on this? It's clear error, isn't it?
No, so a review of the facts actually is for clear error, but neither Judge Callahan nor Judge Walker cited any facts in the record in support of their assessment of OV-14. And so there is nothing to review for clear error. Whether or not the facts support the assessment of a particular variable is reviewed de novo. So unless there are other questions on that, I agree with the prosecutor that if this court disagrees and finds evidence to support OV-14, resentencing will not be required on the basis of the offense variables. However, I do think that proportionality really needs to be addressed in this case. Kind of, my argument has shifted a little bit since I wrote the brief. So the court doesn't need to address proportionality at all if it agrees with me on OV-14 and remands for resentencing with corrected variables. But I think that at least the articulation requirement should be addressed in this case, because unfortunately, we don't have any facts. We don't have any indication on the record at all for why either Judge Callahan or Judge Walker imposed this 50-year sentence in this case. And I think the prosecutor raises some fairly good points as well about the evaluation of proportionality, and is a 50-year sentence completely unreasonable in this case? I don't know. And I don't think that this court can know either. I wonder almost if proportionality, just that concept, is almost a futile exercise debating that today, because we just don't know what the trial court was using. But I will say,
so with regard to the articulation issue, I think, and correct me if I'm wrong, but essentially you're suggesting that Judge Walker, by deferring or saying I'm going to respect the prior judge's sentence, we really don't know what Judge Walker thinks is the appropriate sentence.
correct.
And so the number might actually land and be completely proportional But I think you're suggesting there's some articulation is required for our proportionality analysis. We don't just look at the number. Is that fair?
That's correct. And we don't have,
Why?
Judge Callahan didn't
But
say
why?
anything. Well, I think there are some, first of all, we review within guideline sentences now for proportionality the same way we would for out of guideline sentences.
I don't know. I don't think we do it the same. I mean, there's a presumption and it's a
Yes.
rebuttable presumption. That's
Correct. And if it is a rebuttable presumption, we need to know exactly why, maybe not exactly why, we need something to evaluate the sentence for the trial court to be able to
We're right the
rebut
first
that
time. Exactly.
presumption.
We need to know exactly what the sentencing judge thought when imposing a sentence to determine whether it's presumptively proportional or not.
That is correct, Judge. I think that's true. And I think especially in this case, there are reasons, it's reasonable to question the proportionality of the 50-year sentence in this case for some of the reasons I pointed out in my brief, including the disparity between his sentence and the co-defendant's sentence, which the co-defendant did plead guilty. He was sentenced to 12 years on the minimum. My client went to trial and was sentenced to 50 for the exact same conduct. And the prosecutor points out, of course, that does not necessarily mean that the trial court was punishing him for going to trial. But unfortunately, without some indication of what the trial court's reasons were, we can't really argue against the implication either, given that the facts did not change significantly from the date where the co-defendant was sentenced, who also, by the way, was a fourth habitual offender, and the date that my client was sentenced. And it's a 38-year difference. And I know, there are reasons the court might still choose a 50-year sentence, but unfortunately, because of what I would argue is an unusual circumstance in that particular disparity, at least, we really need to know what the trial court is thinking so that we can evaluate that proportionality. And unless the court has other questions, sir, thank you.
Thank you very much.
Good morning again, Your Honors. David Fox appearing on behalf of the people. As was mentioned, I did concede that OV4 was improperly scored in this case. I certainly won't waste further time on that unless the court has questions. As it relates to OV14, I just respectfully disagree. I know the defense relies a lot on People versus Rhodes. I don't think this is at all analogous to the Rhodes case. In Rhodes, there was no indication that either defendant knew the victim. In fact, I think it was actually the co-defendant in Rhodes who previously saw the victim in a gas station before they confronted the victim and started to beat him at the same time. And all the defendant or the defendant in Rhodes did was to introduce a greater instrumentality of harm, which was a gun in that case. Here, it's very different from that. We have evidence that it was only the defendant who knew the victim. The defendant admitted in his own statement to the police that he was collecting money for a third party, and that one of the people he was collecting money from was the victim. So I think a reasonable inference from that was that it was the defendant who was sort of the instigator in this entire transaction. I would know that at the preliminary examination that the victim did explicitly testify that it was the defendant who approached him first and started dragging the victim back to the apartment where he was ultimately beaten, and then that the co-defendant joined in. So I think the defendant was sort of leading by example, and the co-defendant jumped in after the fact, which makes sense given that the reasonable inferences from the evidence was that it was the defendant who was owed money and only the defendant knew the victim. Once they got back to the apartment, I would just note that there's no indication that these other individuals who the victim testified that he knew were actually involved in this offense. So I don't think they're really relevant to this court's consideration. But once they did get back to the apartment, I would agree that the defendant and the co-defendant sort of showed a unified show of force. They both started beating the victim, but it was the defendant who started beating the victim with a stick. And then once the stick broke, the co-defendant grabbed the other half and joined in. So again, we have the victim acting first, or I'm sorry, the defendant acting first and the co-defendant joining in. It was also the defendant who prevented the victim from using the bathtub after his head was lit on fire. And it was, as this court previously mentioned, the defendant who threatened to kill the victim if he made noise once the police arrived. So I think we have more than just the defendant introducing a greater instrumentality of harm. we have the defendant repeatedly escalating the assault and using greater means to assault the victim and leading by example. At least 2 different times where the defendant acted first and the co-defendant joined in. Given the other evidence that he was the only one who knew the defendant, admitted that he was owed money from the victim. He was the first to approach the victim and demand money, and he continued to demand the money that he was owed throughout the assault. He did more than just introduce the stick, which was the greater instrumentality of harm in this case. He led by example, and I think a preponderance of the evidence did support the trial court's holding. As it relates to the trial court sentence on remand, I would just note that even after Posey, there's no requirement that a trial court state on the record why a within guideline sentence is reasonable and proportionate.
But for us to review on appeal, don't we have to have some understanding of why the trial judge landed on the particular sentence that the judge landed on?
Well, I think the guidelines speak to that. In looking at Judge Walker stated on the record that she reviewed the pre-sentence report and the sentencing guidelines. I think the sentencing guidelines account for the defendant's criminal history, which in this case was increasingly violent and extensive.
So if there had been an outside the guidelines sentence, either up or down, would you agree that the Court on Appeals would have to see some kind of reasoning on the record from the sentencing judge of why there was the departure?
Correct. I would agree.
Okay, so, but you believe that requirement just for appellate review to understand why the sentencing judge landed within a guidelines, the sentencing judge doesn't have to provide any explanation whatsoever?
Well, in this case, I would just note that the sentence fell within the middle of the guidelines. It wasn't a case.
That's not my question. My question is, if it's within the guidelines, is it your understanding that the sentencing judge has to or can offer zero explanation, pick a number, and that's perfectly fine for appellate review?
If it's clear that the court's relying on the guidelines, and here Judge Walker did
Okay.
cite to the guidelines in opposing her sentence.
So why is no explanation needed, in your opinion?
Well, I think the guidelines speak to why the judge issued the sentence that she did. They account for the defendant's criminal history.
So if you're
And
a
the
sentencing judge, it would probably be wise to always not say anything. Just pick a number. It's within the guidelines. On appeal, we have to say, well, it's within the guidelines. I guess it's reasonable, it's proportional.
I understand what your Honor is saying. I would just note that the Posey court did explicitly state that there's no requirement that the sentencing judge articulate on the record why they're imposing a within guidelines sentence. Do I wish the judge would have provided a little bit more of an explanation? Sure. But in indicating that Judge Walker was respecting the sentence of the previous judge who sat there and listened to all the evidence, had reviewed the sentencing guidelines, I don't think there was any requirement that the judge provide any further explanation than that.
What if the judge indicates that he or she is deferring to a prior judge? Is that a problem?
I don't believe so, Judge, because in this case, the court remanded to determine whether the original sentencing judge inappropriately applied the mandatory minimum 25 years to all the defendant's sentences. I think by indicating that the judge was respecting the sentence of the previous judge, it was indicating that she felt that sentence was appropriate, having reviewed the pre-sentence report, which included the facts of the case and the sentencing guidelines. So I think it was an express indication from Judge Walker that she felt that Judge Callahan's sentence was appropriate, and there's nothing wrong with the trial court judge doing that. Other than that, I would stand on my brief. If there are no other questions.
Counselor, thank you very much. Any rebuttal?
Just really briefly, where we disagree on the facts, I'm just gonna trust this court's careful review of the transcripts. I think they speak for themselves. And of course, it's pretty well briefed. And with respect to the articulation of the sentence, I just want to note that Judge Walker did not say that she was relying on the guidelines, nor did she say that she thought Judge Callahan's sentence was reasonable or proportionate. She simply said, I'm going to respect Judge Callahan's sentence. And so I just wanted to make sure that that was really clearly noted. I don't think that that is a basis for her chosen sentence at all. So unless there's other questions.
Thank you
Thank
very
you.
much, Counselor. This matter will be submitted. Moving on to item number 5, docket number 370261-D, People of the State of Michigan versus Robert Stephen Westfield. We have both sides endorsed for oral argument. Good morning, Counselor. How much time would you like for rebuttal?
5 minutes, please, but I don't anticipate needing probably all the time.
All right, you may proceed.
Thank you. May it please the court, Ali Wright from the State Appellate Defender Office on behalf of Mr. Westfield. I wanted to primarily devote my argument today to the first claim presented in the brief on appeal regarding trial counsel's failure to consult with or present testimony from a forensic pathologist who had that subspecialty or subspecialization in interpretive toxicology. And what we're really asking for here, because there was a motion for new trial, there was no Ginther in this case, and we're asking for a remand for a Ginther hearing so that we can further develop the record with respect to trial counsel's reasoning here or failure to consult with an expert with that specific subspecialty. And I really do think that first claim strikes at the core of Mr. Westfield's case here. Because
Your client was the one who was in the back seat of the car, correct?
that is correct, Your Honor.
Yeah, okay, I'm not going crazy.
And I do think that expert claim strikes at the core of Mr. Westfield's case here because the government's medical examiner, their forensic pathologist, was, to put it bluntly, sloppy. He made very serious mistakes in this case. He missed the fact that the decedent had a pre-existing, life-threatening underlying heart condition. It's called cardiomegaly. I'm probably butchering the name. I'm not a doctor, but it's called cardiomegaly. He had a diseased heart, and he had that condition before he ever met Mr. Westfield, before anything kind of happened in this case. And that was missed by the government's medical examiner. And then the government's medical examiner also failed to consider how the numerous stimulants and depressants, uppers, downers, there were 6 different drugs operating in the decedent's body. It's undisputed he took up to like 16 shots of alcohol. There was opioids in his system, cocaine, Xanax, caffeine, all those things working in tandem. And the question is, how do those impact someone who already has a diseased heart, already has an underlying health, a very serious underlying health condition? And then so that wasn't considered because the government's medical examiner missed the fact that the decedent had a diseased heart. And then lastly, the government's medical examiner, the forensic pathologist for the government, failed to consider how the decedent's symptoms shortly before or when he was last seen, and specifically spitting, he was found unconscious with blood, coagulated blood near his mouth. He was vomiting on himself. He was urinating in his pants. He couldn't stand up, face planting, all these things before he was even touched by Mr. Westfield. And all those things indicative of someone who, and as we know that with the number of drugs in his system, I mean, that shows your body is shutting down. That's not normal to be spitting up blood and to be virtually incontinent and not be able to stand. That was not factored in, particularly with the diseased heart. And all this was before Mr. Westfield was really inserted into the equation. And they're all consistent as supported by Dr. Hunsaker with someone who is overdosing. And I don't think that's a far stretch for the imagination for this court in terms of when you see someone with those symptoms. So the jury never learns that the decedent had this underlying heart problem, and that makes overdose significantly more likely. The jury never learns that the decedent was not murdered, or that there's an expert, a medical examiner, a forensic pathologist who would have testified there's no murder in this case, and that his death.
I guess I have a question for you. Doesn't he ultimately opine that because of the degree of decomposition, coupled with the ignorance from his tolerance, complicate the finding that he actually died from combined drug toxicity?
Are you talking about when you say he, are you referring to my
Hunsaker.
expert, Dr.
Yes.
Hunsaker?
Yes. So he does indicate that, yeah, he could have died from an overdose. He can't affirmatively draw that conclusion. And in fact, there were experts that were that defense counsel consulted with and talked with. And I mean, I guess, are you entitled to an expert that's going to tell you, as the trial court ultimately found, are you entitled to an expert that's going to tell you exactly what you want to hear? I mean, what are you entitled to?
Okay, so I think there's two questions from the court there, and I'll deal with but I'm glad you asked both of them, Your Honor. So first, you're right, there's no cause of death. No expert has been able to determine cause of death, and that's different from manner of death, as I'm sure this court is aware. But the difference here is the government's expert determined manner of death was homicide. Another person killed this person. Dr. Hansak.
It's not like there was no evidence of that, correct?
Well, I'm not saying that there's no evidence of that. However, when we're talking about prejudice here, the question is, how would an expert saying, I've looked at the body, these things are missed, and this should have been ruled. And Dr. Hunsaker is a medical examiner with 37 years experience. He's done over 10,000 autopsies, saying that this was not a homicide. This was an accident. And that's critical. I understand no one is, cause of death and manner of death are two different things. The cause of death is going to be a question mark for everyone. But the one thing where they're different is manner of death, and telling a jury manner of death and them only hearing from the government's expert manner of death was homicide in this murder case, versus them hearing from an expert manner of death was an accident. And in fact, the government's expert mixed X, Y, and Z, underlying health condition, all these things. And when you actually look more closely, it's obvious this was an accident and this should have been ruled at least an accident. I think that changes things greatly. And then, Your Honor, you had the question about, I'll just call it, it's kind of the prosecution's argument. I really want to make sure that I responded to that argument because I think it's important. Your Honor, you're absolutely right. There is no requirement that a defense attorney runs to the end of the earth, consult with 3,000 experts or whatever it is until they find that one who's going to agree with their position or say something helpful. That is not our position. Our courts have been very clear. And I really want to make sure my argument is not mischaracterized here because, as I said, again, that is not our position. Our argument here in terms of what trial counsel should have done differently or why he was ineffective is kind of like this Ackley situation. He did speak with a medical examiner. He did consult with a forensic pathologist. And in so doing, he asked him, hey, how does fire impact drug levels in the body? Because their examiner is going to say, well, we don't think he overdosed. How are the fires affecting drug levels? How is it possible he overdosed? And the examiner he consulted with said, I cannot speak to that. I can't speak. I don't have the requisite expertise to speak to that. You need to go talk to someone who does have that requisite expertise. Specifically, you need to go to talk to someone who has a background in toxicology. And so that's the issue. That put trial counsel on notice. Just as the lawyer in Ackley, when the expert there said, you need to go speak to someone with this background or who who might see this differently. He was told by this expert, you need to go speak to someone who has this expertise because I don't, and I can't speak to that. And this is another reason why we're asking for a remand here. This is another reason why we need a Ginther here, because obviously this is just put out in the offer of proof based on my conversation with trial counsel and what he told me in that phone call. But we would like to develop the record. We need testimony. And I anticipate that he will testify consistently with what he told me on the phone with respect to that he consulted with this medical examiner. When he asked him about this, the medical examiner that he was going to think about using told him, I don't have the expertise. You need to go talk to someone with that interpretive toxicology subspecialty.
Didn't he also consult with two toxicologists?
I'm so glad you asked that, Judge Boonstra. So the answer, yes. So there were three. He consulted with two toxicologists, but that's the issue there. So one, he consults with the medical examiner and he says, well, you need to talk with someone with this subspecialty in toxicology. So then he goes to talk to the toxicologist. But guess what? And the prosecutor points this out. The prosecutor crucifies him for this at the trial, because the prosecutor points out, and this comes out through the testimony from the toxicologist, they cannot opine on manner of death, or cause of death. They can't talk. They're not allowed because they are not forensic pathologists. They're not medical examiners. So that's the disconnect here. These experts are siloed to their respective fields, and what he needed was someone who straddled both and could speak to both, and that's precisely why the prosecution scored major points. They argued specifically in closing argument. Yeah, all that stuff is great about what the toxicologist said, but what did she not say, and what can she not say? One, she can't say the manner of death in this case with respect to the decedent. She can't talk about causes. She can't do any of that because she's not qualified to. And so all she can say is just these general things about drug levels in general, but she can't even really specifically talk about the drug levels in this case and what happened to this body like a medical examiner or a forensic pathologist can, because she doesn't have the requisite expertise. So to answer your question, Judge Mistra, he needed to talk or speak with, he was put on notice to speak with someone who could speak to both, specifically someone who was a forensic pathologist with a background or with a subspecialty in toxicology. And that's precisely who I spoke to, or the defense on appeal spoke to. And that's Dr. Hunsacker's background. He has that subspecialty. And as a result, I mean, it paid dividends because his findings in this case are, in terms of the sloppiness of the government's medical examiner, and his findings, I think, would have seismic change. And I think it's also important for this court to remember, I guess we're kind of jumping to prejudice a bit. I think it's also important for this court to keep in mind what we have going on here, which is, in addition, I do find it puzzling, this argument from the government that.
Let me ask you a question.
Sure.
So let's assume that we agree with you.
Okay.
So I'm interested in what the charge would have been then, in assuming, I think there's strong evidence your client brutally beat the victim in the back seat. But let's say he beat him, causing significant blood injury, but then the victim died of a drug overdose. Your client did not seek any medical attention for him, tried to cover up by cleaning the car, and then ultimately put him in a house in Detroit and set it on fire. So assuming all that happened, but the victim did die of an overdose, what would have been the appropriate charge in that instance?
So and I think even trial counsel talks about this in his closing, but he had no support for it because he didn't get these experts. But Michigan law does account for that, which is essentially disposing of a body.
But also beating this person brutally.
Sure, and maybe that's an assault. Maybe that's but what is not, which is what Mr. Westfield was convicted of. What is not is first degree murder. There's a difference. So and I would point out all these facts, and I'm sure the prosecution will list those facts. And Judge Schwartzel, you seem to be very well aware of all those facts, that circumstantial evidence. All of it is also consistent with disposal of someone who died essentially on your watch, for lack of a better word. And yes, is that a crime? Yes. Is it first degree murder? No.
Would it have been felony murder?
The felony being the
brutally beating him?
I see. Well, I mean, I think this kind of gets to, forget which claim it is, maybe number 4. I think it's claim number 4 in the brief. That kind of gets to the issue of causation, and specifically, there's this, and it's a good, I'm glad you raised this. So again, there's no cause of death. There's no time of death. There's no place of death. All those things are question marks. That's undisputed. And so to answer your question, there's this 4 to 5 day period where we don't know when or where and how Mr. Guthrie died. And so, yes, I would agree in terms of if there was beating and he shortly dies after, or that caused, that would be a problem. But the issue is we don't have causation in this case. So there's that 4 to 5 day period. Even the government's medical examiner testified that it could have been possible he was just walking by this house, and I think that's a little improbable, and it collapsed on him. The point being, we don't know what killed or if he was killed, at least by another person, the decedent in this case. And so the beating that you're talking about, there's that kind of presumption or what's the lack of it's based on a premise that the beating caused the decedent to die, but we can't really make that we can't really have that premise given that there's this 45-day period where we don't know what happened. I mean, it's one also possibility is he was let go.
I think, so it's the inference. So again, go back to my hypothetical.
Okay.
Not hypothetical. Your client brutally beat this gentleman in the back seat of the car. And let's just assume that victim died in the 4-day span of a drug overdose. But I think it's also fair to say that there's a strong inference that that victim did not leave, was in total control of defendant's possession over that 4 days, because your client was one of the last people to be seen with him. There's evidence that he beat him. And then 4 days later, the victim's body is found in a burned building. I don't think it takes a great leap of logic to make the inference that your client had possession of that body for those 4 days. So let's assume that's all true. I'm still getting back to, would there still be enough there for a felony murder conviction?
And your hypo is assuming that Mr. Westfield had possession of the decedent's body that whole time.
Yeah, I'm making that inference based on the evidence.
But do we know, I'm trying to help with your hypo, do we know when in that inference the decedent died?
Sometime, let's assume he died of the drug overdose.
He died of, and we can assume he died of the drug overdose 4 days later. So is my client still in possession of his body during that whole 4-day period is what you're saying? I'm trying to understand your hypo. I'm sorry.
There's no evidence that this victim ever regained consciousness, was walking around, enjoying life, and then just found himself in a burned building. The strong evidence, or the inference from the strong evidence, is that your client beat him. Your client had possession of that body. At some point, the victim died and then ended up burned almost beyond recognition in a house. So that's the facts and the inference I'm making. I'm only asking, even if he did die technically of a drug overdose, would there still be enough there for felony murder in terms of, is there any prejudice here?
I think I understand your question. I think my answer is no. And I think the reason is, and I hope I'm going to tell me if I'm not answering your question, is because of that time gap, because we can't I mean, it's all about causation. And I understand you're saying he, in your hypo, he'd be in possession of the body this whole time. But even if he's in possession of the body or they're around each other the whole time, I think you have to still tie that initial felony you're talking about, the beating, to the death. And I mean, I think we can try and think about this in other situations. Like if someone robs a store, but then there's like 4 days later, someone, at some point there's a break and in the causal connection. I think you're pointing to, well, maybe there's no break between him having possession of the decedent, but there is a break with respect to, I think under your hypo, with respect to the assault.
Okay.
I hope that answered the court's question.
You did, thank you.
Right. So I just to close on this, I'd remind the court, we have a case where there's no murder weapon. There's no eyewitnesses to this murder. There's no cause of death. We don't know where the death occurred. We don't know when the death occurred. And trial counsel told me, and again, we're asking for this Ginther hearing. Trial counsel told me that if he had found an expert like Dr. Hunsaker, and again, it doesn't have to be this one expert. It's just the thing that was unreasonable was not speaking to someone with the requisite qualifications. If he had, he would have presented testimony from him, which is not surprising to me because he argued trial counsel argued to the jury in his closing that the decedent died from an overdose. And the prosecutor called him out on that. The prosecutor said, yeah, that's great and all. There's zero evidence of that. And in fact, the evidence is the opposite. The only evidence the jury has is that the decedent in this case died was essentially killed, and that, but there's no evidence to support overdose, and that the government's expert actually testified it was not an overdose. So he made this argument, and it's not even that he didn't have support for it. The only evidence on that subject actively refuted his argument. And so that's really the ineffectiveness here. He just really had no support for that. And in fact, the evidence disputed. So what we're really asking for is to be able to make a more fully developed record so that this court can make a fully informed decision here. And specifically why trial counsel did not consult with a forensic pathologist with this toxicology background. And so for that reason, we're asking this court to remand for Ginter, unless there's any other questions from the court.
No other questions. Thank you very
Thank
much,
you.
Counselor.
Good morning, Your Honors. Isaac Skaggs, Monroe County Prosecutor's Office, appearing on behalf of the people of the state of Michigan. I'm primarily going to focus my response as to the first issue, as counsel did, regarding ineffective assistance of counsel. I think it's key here that we're evaluating this in terms of an ineffective assistance of counsel claim. Really the question here is, what standard are we going to use to determine whether or not trial counsel's performance was deficient in this situation? I cite Ackley in my response. I go through a breakdown of it. In that case, there was determined to be a deficient representation. But to be frank, that what the court determined in that situation was, it was really a complete lack of any investigation and learning the area in which the defense would need to be based around. In that case, trial counsel spoke with one expert, didn't consult with anybody else. The one expert he consulted with said, I don't agree with you, but also this is a very hotly disputed topic in the medical community. You should probably go talk to somebody. Here, go talk to this guy. Defense counsel in Ackley doesn't follow up on that, just goes with this one conversation with this one expert, doesn't really investigate at all, doesn't do any additional investigation at all, doesn't review pertinent literature on the matter, and goes into trial with that background. What we have here is very different. Just based on the offer of proof that appellant's counsel has provided the court, we know that trial counsel in this case consulted with not one, but three different experts. First individual that he spoke to indicated, you should go speak with a toxicologist on this. I can't opine on drug levels. He goes and talks to not one, but two of them. One of them is called at trial, although it wasn't counsel for Mr. Westfield that called this particular expert. There was a co-defendant here. His counsel called that expert at trial. The jury.
About opposing counsel's point that defendant's trial counsel spoke to the wrong expert, should have spoken to a forensic pathologist with a toxicology background, and it would be akin to talking with a podiatrist about brain cancer.
Well, Judge, I would say in your scenario there, that would be ineffective, right? If you speak to a podiatrist about brain cancer. But if I did defense work, if as a defense attorney, I go and I talk to an expert who tells me, hey, you should probably go talk to somebody in this area about, if your theory is based on the evidence, I think this individual might have overdosed. I can't speak to that. Go talk to a toxicologist.
Is it ineffective for trial counsel not to have understood the limitation of what the expert could speak to, a toxicology expert could speak to?
I don't believe so. I think based on what was presented at trial, based on the types of questions that were asked, and based on what the theory of the defense appeared to be, if you're trying to determine what is an overdose, you speak to a toxicologist. I actually think that their expert was able to provide the jury with some information as to what the normal levels are of the substances that were located in what the normal levels are of the substance that were located in the victim's system, and speak to whether or not those levels could be potentially lethal, even if they're within the, let's call it, accepted range for lethality, if I recall that correctly. So I think that if this is your theory and you're going and you're consulting with this individual on that, you've done your due diligence at that point. You've done your preparation at that point. You have a good background in what your defense is. You have an understanding in what you're trying to argue. I think if we are to be clear, I'm not saying that counsel for appellant is arguing that trial counsel should have talked to 3,000 experts here. But there does come a point where we draw a line. And it's my contention that if you speak with one expert who has knowledge on the situation, they refer you to another type of expert, and then you follow up with two experts in that area, that you have done your due diligence and there's enough there to go on to proceed to trial. And maybe you score some points, because frankly, let's say this, we go to another scenario, speaks to a forensic pathologist with the specific specialization that we're discussing, and with interpretive toxicology. They tell you no. Do you now have to go to another person and another, right? There needs to be a line here. And I think wherever it's reasonable to set that line, I would argue in this case, trial counsel more than met it. And just very quickly, Your Honor, I think, we touched on sufficiency evidence, which of course goes to prejudice. There's a lot of evidence, both direct and circumstantial, regarding the death. We had an eyewitness account indicating that defendant brutally beat the victim, in this case, in the backseat of a car for an extended period of time. We know that victim was alive at that point, and then placed victim in the trunk of the car. We know that the beating was brutal, just based on the amount of blood that was there. We know that the defendant in this case he was the last person seen with him. We know that he had him in the car. We know that he got him into the trunk. We know that we have very strong evidence that he ultimately was the one that was one of the individuals that disposed of the body. Cell phone records place him near the location of the house that burnt down, of the burnt house with victim's body in it. The reason that there are some gaps in terms of murder weapon and precise cause of death, expert for the people ruled it a homicide unspecified, was because the defendant took significant steps to dispose of the body here. The evidence went up in flames as the body was burned. So those things are addressed by the burning. And again, I think there's extremely compelling evidence for a jury to determine that the burning was the act of the defendant in this case. Unless there are any additional questions.
No further questions. Thank you very much.
Thank you.
Counselor, for rebuttal.
Just 2 points. The brother counsel discussed Ackley, and again, our position here is it's not just about consulting with one expert, or in this case 3. That Ackley's not just about consulting with one expert. Ackley's also about what the expert that the defense attorney there consulted with told him, which was, you need to go talk to another expert. And that's kind of the same thing that happened here, where we have the expert that trial counsel consulted with told him, I don't have the requisite expertise. You need to go out and find. I think Judge Swartzel, if I'm recalling correctly, asked a question about should trial counsel have been on notice that the limitations of a toxicologist's testimony. And I'd say absolutely. For one, you would have consulted with the toxicologist in theory, and known those limitations. And two, I think any competent defense attorney knows that, as the prosecution pointed out, only a medical examiner or forensic pathologist can really speak to manner of death or cause of death. And that's really where the toxicologist's testimony there was diluted, because she just could not speak to this case. She could talk about drug levels generally, but she couldn't speak to this case. She couldn't speak to the decedent in this case and his drug levels, and specifically whether this should have been ruled an accident. The brother counsel also just asked kind of where the line is. And again, I think the line is simply going to a forensic pathologist who has a subspecialty in toxicology. It's as simple as that. And you don't have to consult with more than one, just one. If whatever answer they give you is the answer they give you, but what's not reasonable is to not consult with the right kind of expert. And that's what our position is here. The last point I wanted to at least touch upon is, I did want to go back to Judge Schwartzel's question from earlier, because I was thinking about it a bit more. And I think that if someone assaults someone, if I strike someone, and then I hang out with them for a few days, and then they die 4 days later from a drug overdose, I don't think me in that scenario or anyone in that scenario is on the hook for felony murder, because at that break in causation. I understand they're still hanging out, but there's a break in causation. There's a up to 4-day break, however many it is, between the beating and the death. And specifically, we also know that the cause of the death is overdose in this scenario. So I really think it does come back to that causation and that kind of break between the underlying felony and the subsequent death several days later. So I hope that answers the first question.
The position is they were hanging out together during that time.
Well, I don't think I have to
Perhaps
necessarily.
he was unlawfully imprisoned, which would be another felon, right?
Well, so that is actually the felony that Mr. Westfield was convicted of in terms of the. But again, that's the issue with this several day period. We don't know what was going on during these several days. And so that's kind of goes to the sufficiency claim in this case, where we have no murder weapon, no eyewitnesses, no causation, no place, no time of death, nothing. Anything could have happened during those 4 to 5 days. And so, yes, I mean, it doesn't have to be my scenario if they're just hanging out. I mean, but to be honest, these are people who know each other. They did, these aren't like strangers. But there's nothing to show, at least beyond a reasonable doubt. And these are all questions for a fact finder or for a jury, that he was in prison the entire 4-day period, that he's in prison that entire time. There's many different scenarios I can apply there. And I think we cite a case, I'm blanking out on it off the top of my head, in our sufficiency section, that shows that where there is this also explanation that could have occurred, that's a problem for sufficiency purposes for the people. Thank you.
Thank you very much, Counselor. This matter has been submitted. Moving on to item number 6, case number 370971-T, in re Walter Sparling Revocable Trust. We have both sides endorsed for oral argument. Good morning, Counselor. You have 30 minutes. How much time would you like for rebuttal?
Well, I'll reserve 5, but I won't get to 30 either. For the record, David Hybor on behalf of the petitioners, who are 4 of Walter Sparling's 8 children. The issues in this case or the history at least, is somewhat very convoluted. And Judge Tomlinson, in his opinion, did an excellent job in setting forth what has transpired. And what we have is, in 2012, the Walter Sparling created an irrevocable trust, which was eventually dissolved due to mental capacity. Mary Sparling was Walter's wife, and she started an action in 2017 to challenge the trust. That matter went to a verdict in February of 19, and the jury found that Mr. Sparling did not have the mental capacity. when the Walter Sparling Irrevocable Trust was funded, assets from the Walter Sparling Revocable Trust were transferred to the Irrevocable Trust. So one of the claims here, when the trust is dissolved, is Mary Sparling was not receiving income from the assets of the Walter Sparling Revocable Trust because they had been transferred to the Irrevocable Trust. And I think I said that correctly. When the jury, and if I didn't, I'll be corrected. When the jury verdict was rendered, there was then a bench trial on various equitable defenses. And the jury verdict was rendered in February of 2019. And in April of 2019, counsel for Mary Sparling sent a demand to the trustees of the Walter Sparling Revocable Trust to be reimbursed for a variety of items that she has not received because of the Walter Sparling Irrevocable Trust being created. That demand was on April 10, and on May 11th of 2019, 31 days later, depending on how the documents exchanged hands, a settlement agreement was reached. And that's still at a time when the equitable defenses were still pending before Judge Tomlinson, and that verdict did not come down until December of 2020, which is when Judge Tomlinson then dissolved the Walter Sparling Trust, and there was never a decision made as to whether the trust was void or voidable. It was simply dissolved in December of 2020, and eventually the assets were transferred from the Walter Sparling Irrevocable Trust to the Revocable Trust in May or March of 2021. While all of this is going on, there is various litigation in the St. Clair County Circuit Court by some of the family members against, by some of the children against each other. Walter had 8 children. I represent 4 of them: John, Vicky, Judy.
I don't mean to cut you off, but what was the problem here? I mean,
The problem,
I know there's a long history, there's multiple cases, but specifically what was wrong here? The settlement was too early, it jumped the gun. Like what was the specific problem here?
a variety of those, because number one, we didn't know at the time whether Judge Tomlinson in the Irrevocable Trust was going to order that the beneficiaries who received the money from the Walter Sparling Revocable Trust distributions return the money. Because the Walter Sparling trustees of the Walter Sparling Revocable Trust, they did nothing to damage Mary Sparling.
Are you suggesting that a settlement cannot resolve potential claims?
No, in fact, Judge Tomlinson noted that, and I'm not suggesting that. However, to go ahead under 700.7111, to do that, the trustees have to be able to provide proper representation for all of the interested parties, of which contingent beneficiaries are interested parties. And at that time, the trustees were Greg Sparling and Wayne Sparling, who at that particular time, Greg Sparling and 2 other individuals were suing 3 out of 4 of my clients in the St. Clair County Circuit Court. So that clearly there was a conflict of interest. Clearly, because Judge Tomlinson noted under 700.3805 that there has to be, you have to be free from a conflict of interest. He properly noted that. He never addressed the fact that of the warfare, I hate to use the word, but Judge Worsley, you indicated the history. So we have 2 individuals who are on the different side, are allegedly representing and binding my clients. At no time were my clients contacted as to what was going on. And I think also under 700.7111, you cannot destroy the manner of the trust. And that is exactly what was done here, because the trustees in the testimony in this case made it clear they did not care what Mary Sparling's needs were. They simply said, if she received money before, she should get it now. Because under the trust, the trustees are to look at whether or not the assets are sufficient for her care and support before they can invade principal. And if they're insufficient, they are also to look at what other assets she has available.
Did the trustees have the advice of counsel when they entered into the settlement agreement?
Yes, they did.
Okay.
And they clearly indicated, Your Honor, that they did not care what her needs were or what her other assets were. If she received money before, she should receive that money right now.
And did Mary settle for less than what she was otherwise entitled?
That was never determined. And one reason.
That's not my question. Did Mary settle for what she was, what was reasonably anticipated would be what she was entitled to?
I'm not trying to dodge the question. That's literally never been determined because
But again, if you're going to settle a potential claim, that's always an argument. Well, it's never been determined by a trial court. You can settle potential claims.
I agree.
So is there a reasonable argument that Mary was entitled to more than what she settled for?
There's a reasonable argument that could be made, but not against these trustees and against the irrevocable trust. It should have been made against the beneficiaries of the irrevocable trust. Because these trustees, arguably the only claim against these trustees of the revocable trust is that they funded the irrevocable trust. Because there's no question that the Walter Sparling Revocable Trust never received the money which was dispersed to the beneficiaries. That money was never received. It's gone to the beneficiaries. And at no time was there ever any attempt to claw back any of those funds. And I understand they've got an easier source. Mary Sparling sends a letter to the Revocable Trust, and granted, everybody are family members here. And the Revocable Trust, in 31 days, puts this transaction together while they're still having an issue as to whether the Revocable Trust should even be dissolved. So, and I understand you can go ahead and deal with potential claims. I get that. Here we have a situation where Mary Sparling, when she ends up receiving the money, then diverts it and pays it to her other 4 children. So it's a conduit to simply the money comes in and goes out, and my 4 clients receive nothing. Now, granted, as part of the revocable trust, she can't do that. As part of the revocable trust, she gets the income, no question about it, and she can also get the principal if the trustees have determined, in their opinion, that the assets are insufficient to meet her needs. They never did that. They testified without a doubt, didn't care, didn't look at it, didn't consider it. And so what they looked at were 3 years of payments that Mary Sparling received during Walter Sparling's life, because Walter died shortly after his irrevocable trust was established. And they used those numbers to figure out what Mary should have received. Never contacted any of the other beneficiaries to see what those numbers meant, where did they come from. Those were estate planning figures, because Walter Sparling was very conscious on not having to pay federal estate tax. And he was very concerned about that. And that is the testimony from John Sparling, that anytime a certain fund would get near $5 million, assets were transferred to Mary Sparling, no question about it. But it was the purpose of that, because the trustees in this case clearly indicated they didn't care what her needs were, and they didn't care what her assets were. And that's why, from a standpoint of a simple trust accounting, they fall short on that, but they can get around that in the settlement. I submit, Your Honor, that they did not, clearly the 2 trustees, Greg and Wayne Sparling, had a conflict of interest with my clients. Even though I recognize that trustees can bind the other beneficiaries, provided there is no conflict of interest. In this case, there couldn't be a bigger conflict of interest, as set forth by Judge Tomlinson in his history of the case. And this course, of course, can easily see that history. Additionally, the non-judicial settlement appears to be more of a matter to deal with routine administration of an estate that is not embroiled in litigation. Here, the only basis, and in my opinion, under MCL 700.7111, is that the trustees may have some liability to the trust, or to the claimant. And in my opinion, in this case, that is simply not the case. Considering these matters and this, if there was going to be a settlement, you certainly don't do it with this kind of money, with over $1 million, when a claim is still pending as to whether the Walter Sparling Irrevocable Trust is even should even be dissolved. Thank you.
Thank you.
Good morning. If it pleases the court, John McNamee appearing on behalf of Mary Sparling. Judge Tomlinson probably has the.
I'm sorry, Counselor, I don't want to interrupt you. Are both counsels splitting your time?
Yes.
Okay, how much time are you taking?
Let's just say 20 minutes, if that.
All
And
right,
then he has 10 minutes then.
all right, I'll let you know when you're at 20 minutes.
Sure. I'd indicate to the court that Judge Tomlinson has a firm grasp of the facts of this case, the parties in this case, and also the trust documents itself.
Has he handled all of these Sparling
All of it,
cases?
all of it.
Even the one like that involved the company, the Sparling v.
No, that
Rumpel?
was in the circuit court.
Okay.
But all the matters involving any trust or revocable trust or any estate matter, Judge Tomlinson handled it.
Okay.
Starting in 2017, right on up till his conclusion of his opinion. Judge Tomlinson had conducted the trial at the court level, gave everybody an opportunity to testify, bring in evidence and exhibits which are attached to the record. And it should be clear that at no time, they tried to make an argument, and I put it in my brief. They put it in their petition, this petition that we're here for, that they're seeking that Judge Tomlinson ruled not to be in their favor. They argued solely that the only standard was what Mary Sparling needs. They didn't even include the term what she was accustomed to in care and comfort, which is within the statute. It's also within the trust itself. The trust itself says that. When their petition, they excluded that, tried to argue, well, Mary Sparling doesn't need this money. In fact, John Sparling testified that she was old and she didn't go anywhere and she didn't need the money. Now, that didn't go over with the jury. It didn't go over with Judge Tomlinson either. It is also not consistent with the trust itself. Understand that Walter Sparling set this revocable trust up. When he died, that revocable trust was to all of the income be generated by that revocable trust was to go to Mary Sparling, his wife of 66 years. Mary Sparling was 87 when this started, this litigation. She's going to turn 97 in 2 months. She is in very good health. They attempted to say that she was manipulated at trial. That didn't fly with the jury. Her testimony was very good. Now they're suggesting to you, well, and I got to say this, I take exception with counsel coming before the appellate court and telling this court that Mary Sparling then immediately took all the money that she received and diverted it to these selected children. That's not in the record. There's no way that is in the record. It is not a fact. That's an assumption they've made and an argument that somehow this was schemed to get the money for her. The money that's in this revocable trust is still going to the 8 children, all 8 of them, including these persons who are suggesting that she's done something nefarious. That money in the Walter Revocable Trust still goes to the 8 children, but it doesn't go to them until Mary dies, because she's entitled to all the income during that period of time she's alive.
How does this go to whether the settlement agreement was appropriate?
Well, that's what was the issue of viability. So understand that when the irrevocable trust was done, immediately the income from that, they took the assets from the one big income producing asset, they put it in the irrevocable trust. So it denuded Mary Sparling from receiving any money from that trust and from that big
That
asset.
trust being the revocable trust.
Yeah, they took it out of there, and so she no longer had access to that income. Who got the income? The 8 children were getting it. They were getting $2,000 per person a month. That's $16,000 a month. And my math would be it was $196,000 a year. And over 5 years, it was $1 million that they got before the judge put an end to it. And she didn't get that money back. That money was paid to those 8 children. They were not entitled to get that until she died. And now they're here before this court, 4 of them, and saying, well, no, she shouldn't get this money. This isn't her money. They've already been overpaid $1 million. Now we don't want that. We want her to be deprived of this income while she's still alive, which is contrary to the intent of the trust. And Judge, and just real quickly, in the opinion on page 11, Judge Tomlinson did deal with this issue about this improper motive. The second full paragraph, it says, petitioners also argue that the co-trustees had an improper or dishonest motive, intending to remove assets from the trust and conveying them to Mary so that Mary could determine their ultimate distribution. The court does not find this argument persuasive. Petitioners presented no evidence in support of this assertion, other than the fact of the distributions paid to Mary. Mary was entitled to the income from the trust. Because of the creation of the irrevocable trust, assets were removed from the trust, which reduced the income Mary could receive. Ultimately, after the irrevocable trust was determined to be void, counsel said that it wasn't determined to be void. It's right in the opinion. And the assets returned to the trust. Mary demanded payment of the lost income and reimbursement of attorney fees and costs incurred to protect her rights under the trust. Execution of the settlement agreement and the addendum was proper. And I would indicate to you, how did the trustees, first of all, they get a demand that now the jury has determined it's an invalid trust. So there's an exposure of all this money that she never received. I send a demand letter. The trustees get an attorney, they respond to it, and they also hire an accountant, CPA, to review. They determined the only way to objectively determine what she would have been receiving and entitled to and accustomed to was to look at the 3 years prior to Walter's death, what she received. They used that, and all the exhibits were produced at trial. They used that with the assistance of the attorney, the assistance of the accountant, and they determined what she should be reimbursed, what would be a fair settlement. They reduced the amount that she was claiming by 40%, saying there would have been a tax consequence. Also, the attorneys recommended that there should be a cost of living factor involved. The trustees decided, no, we're not going to do that. We're just going to come up with the accountant's figure as to what's there minus the 40%. And a settlement was negotiated. That settlement agreement was negotiated between the interested parties. Now, counsel says, well, that should be all of the parties involved, all the trust beneficiaries. What the court rule says, and when we're talking about the settlement, you look at 700.7111, that section says trustees have the authority to settle a case. And they say specifically, subsection 5, as used in this section, quote, interested parties means persons whose consent would be required in order to achieve a binding settlement were the settlement to be approved by the court. And what there's, and the trust document itself says the trustees have the authority to settle claims. The trust code says that. Specifically, that section I just read says the parties who have the authority, that's the trustees. Otherwise, what they're suggesting is, let's say you have 8 children and they're all going to be contingent beneficiaries, which they are. In order to reach any settlement, all 8 of them have to agree. What if you get a 4-4 vote? I mean, it makes no sense. And there's nothing in the trust code and there's nothing in the trust that says the consent of all the parties, excuse me, all the trust beneficiaries must be achieved before the trustees can make a settlement. Their remedy is what they're doing here, where they're challenging the efficacy of the settlement. But Judge Tomlinson was aware of all the facts involved in this case, and he found it to be most appropriate and probably most importantly, it was consistent with the intent of Walter Sparling to provide for his widow all of the income after his death. And I'll just wrap up one more thing. If you looked at, they said, well, counsel said, well, all they did was they didn't look at what she needed. They just said, well, what was she receiving? Well, that goes to what you're accustomed to. But if you're going to challenge that the trustees' decision was inappropriate, then why didn't they come into court and show that it wasn't appropriate, what was allocated to the widow, my client, Mary Sparling? And I cite on page 15 of my brief, it says, tell me what your mother was accustomed to in 2012. 2012, basically she wasn't accustomed to anything. She was staying home all the time. My dad was sick off and on. They didn't go anywhere. They didn't do anything. Then I go in, what is the financial resources that she was accustomed to? What did she have available to her? Answer, really, I can't tell you. Now, this is their CPA, John Sparling, at trial. Followed up, asked about, you testified your father gave your mother sums of money for estate tax purposes, right? He says, yes. Well, is it a fair statement that those checks were dividend paying stocks? Yes. For the most part, And what was the reason that your father did that? That she would then have the payment of dividends so she could spend it as she saw fit. Answer, I don't know what he thought on that. Answer, question, okay, I won't answer that, no. And then finally, I'll end. When they were asked about their examination of the financial information that the 2 trustees provided with the assistance of the attorney and the assistance of the CPA, the question is asked. So just final point, we have this language that says the trustees are to make a determination based on her care and support as to what she's accustomed to. So that's the standard that's set up in the thing, that the objective standard. And the only way to make that determination is to financially look back at the documents and see what she was accustomed to, correct? Answer, yeah. Question, all right, you haven't done that, have you? No. And then lastly, basically you're saying that basically he testified the trustees are wrong, and this is the question. So you're basically saying they're wrong. You don't know what your mother's needs, or if not needs, but what her expenses have been. You don't know what she's financially accustomed to. You don't know what her position is. You haven't come up with any other document to suggest that this is correct and what she was financially accustomed to. But you just say they're wrong. Answer, they are wrong. At trial, they presented no evidence that this information that was provided by the trustees through the accountant and through the attorney and through the exhibits was in manner not correct. It's just preposterous. They're now here suggesting that let's keep her from getting the money that Walter Sparling set up in the revocable trust that she was to get from the day he died.
Thank you, Counselor.
Good afternoon. I think may it please the court, Alan Francis for the co-trustees, Wayne and Greg Sparling. We've covered most of it. I'm not going to do it. I just wanted to touch on a few issues because I think sometimes they get a little bit confused here with the accustomed to calculation and the settlement agreement. But I think they're related to show the diligence that my clients, the trustees, gave to this matter. So the accustomed to calculation was actually derived in December of 2017 before the settlement agreement was made. And at that point, Mary Sparling, again, she had done this historically. That's a testimony in the record. But again, she'd gone to Wayne Sparling this time, who was universally elected successor co-trustee by the beneficiaries. And she said, Dad, Walt used to pay for all these expenses and the trust isn't doing it anymore. I'm not getting what I used to get. Can you take a look at it? Wayne gave it to Greg. Greg testified he did a full-blown accounting. This was in 2017. Made this determination at that point in time in 17 that he believed they had shorted Mary over $580,000 approximately in accustomed to payments. What the trustees did at that time is they brought the payment up to the accustomed to level, but were making no movement on the arrears that they would have owed her at 580. The trial goes on. The irrevocable trust, the life insurance trust, is reversed. Mr. McNamee makes his demand and says, not really about accustomed to, but hey, this asset that the trustees didn't go pursue should have been in this trust, and had it been in the trust, Mary Sparling would have been entitled to this income. So my clients are sitting there knowing they potentially have a $580,000 claim on the accustomed to payment, and now they have $1.8 million claim on this lost income. Judge Tomlinson specifically determined that in regards to the settlement agreement, the co-trustee's failure to act on Mary's behalf as the income beneficiary, producing asset was transferred to the trust, certainly gave Mary an enforceable claim against the trust or the co-trustees. So they're sitting there with this demand, $1.8 million. They resolve it for $730,000, which is actually ballpark of what they thought they already owed on the accustomed to without even having the claim. Greg Sparling testified he thought it was the best thing that had ever happened to the trust because it put to bed all of these issues. The income producing asset, which is a strip center, is back in the name of the trust. When Mary's entitled to income, there's no dispute that none of these children or other beneficiaries were entitled to income. She gets it till she dies, then it goes to the beneficiaries. That's where we're at. My client sought professional counsel with respect to the accustomed to payment, both in a CPA and with Walt Sparling's attorney who drafted the trust. As Mr. McNamee indicated, that attorney said, you really ought to give a cost of living an adjustment, and they didn't do that. They went with the lower number. As soon as they got Mr. McNamee's demand that resulted in a settlement agreement, they went to the council, same council that drafted the trust for Walt Sparling. That council negotiated the agreement. The agreement's fair. Judge Tomlinson determined that there were potential claims, determined that the trust allowed resolution of the claims, determined that the beneficiaries were protected. And the trustees, like the appellants here, are remainder beneficiaries of this trust, as well as trustees. So they all sit in the same position when this is done and over with respect to this trust. So they acted reasonably, they acted diligently, they resolved the claim, which judicial economy, the trust, the code, the trust code all promote that we do. Judge Tomlinson went as far as to go through all the elements and approve the settlement agreement. There is no basis to set aside. It does not violate the material provisions of the trust, and Judge Tomlinson specifically approved it.
Thank you, counsel. Any other questions? No. All right, rebuttal.
Just a couple of items. And it's not a big issue, but contrary to counsel's comment, the Walter Sparling, granted, Judge Tomlinson ordered, it's a appellant's appendix 250 or 582. It's the Judge Tomlinson's opinion where he concluded that the equitable defenses were not valid, that the trust is not, he found that the irrevocable trust is not valid. The trust must be dissolved and the assets returned to the revocable trust. And then he went on, the trust's co-trustees shall convey the assets immediately to the revocable trust and within 30 days file an accounting. So the issue of void and voidable was never determined. Council also indicated that when you read MCL 700.71115, that where interested parties have a, I'm not sure if you used the word a vote, you could never have a settlement. And I'm not going to suggest that if you try to get these 8 people together, it would be like herding cats. But this section that he refers to is on non-judicial settlements. Obviously, the trustees could file an action to settle a claim. And I have no question that an allegation is out there, but they used a non-judicial process. And I think that is significant because they used a non-judicial process. It binds all 8 of the contingent beneficiaries because Judge Thomason found that the 2 trustees never mentioned the word whether there was a conflict of interest, mentioned the statute, and simply said the 2 trustees properly represented my 4 clients. Respectfully, that isn't the case. Further, counsel indicates that we have attempted to totally disregard the trust. And that is not true. It's section 8. The trust is section 8. I'm sorry, I don't have the appendix right handy on that. But if in the trustee's opinion, the income from the trust, together with other resources available to her, is not sufficient for her care and support. So first of all, I agree, there's no question all the income goes to Mary Sparling. And when they look at whether to invade principal, you look at the income and other resources available to her. They did not. They said on the record, we don't care. Then if you look at the income and that other resources, if they're not sufficient for her care and support in the manner in which she has been accustomed, then you can invade principal. Every time the question was asked, the response was in the manner in which she was accustomed, in the manner in which she was accustomed. They never looked at her needs and they never looked at other resources available to her. We weren't trying to reinvent the wheel. The question was, what is the money needed for? Because we were going through an accounting at that time. This was the hearing on their accounting. What did you rely on? We didn't care. So they're invading principal. This was never an issue about invading, you don't invade income. This was never an issue about her getting the interest, her income. This was an issue of invading the principal. And there's a 2-step requirement. And they simply said, we didn't care what her other assets are. We didn't care what her needs were. From that standpoint, that's clearly breaching their trust obligations. And I don't want to say the way they get around it, they go to the settlement, but they never had the approval. And I agree, my clients would never have approved that had it been through a non-judicial process. They had every right to file something with the court. They never did. And because of that, clearly this settlement is outside of the process of the trust under 700.7111. And my clients clearly, with the conflict that is here. Yes, Judge Tomlinson handled the probate matters, which at the time of this settlement, there's only one probate matter before him, the irrevocable trust case. The other cases about the businesses, those have been going on for about a couple, 3 years in circuit court before Judge Kelly. And that's where my clients were, the 3 of the 4 were being sued by 3 of the other 4. And so there's the conflict of interest. And it is never addressed. And I think from that standpoint, that is fatal right there. And I would ask that you reverse the judge's.
Sorry, that was the timer.
I was afraid it's a call from me.
Thank you.
Thank you.
A very nice timer.
I wonder
Like an
if
ice
you-
cream time, right?
I wonder if you have a special thing, that's just your cell phone.
All right, thank you very much. This matter has been submitted. For our last matter for the 10 a.m. docket, it's item number 7, docket number 373-849-T. So Jin Kim versus Essentia Limited LLC. Did I pronounce that correctly? I thank you. All right, both sides are endorsed. Counselor, how much time would you like for rebuttal?
5 minutes, Judge. And good afternoon, Your Honors. May it please the court, Aaron Cox. I'm appearing on behalf of the appellants and cross appellees. Your Honors, it's a little bit late in the docket. I'm going to take Judge Bazzi's comments at the introduction to heart. There are 3 issues before this court. The court should rule in the favor of the appellant cross appellee on all 3 of these issues. The first one is to address cross appellee's argument that the motion for summary disposition should have been granted on mitigation because there was no genuine issue of material fact before the court. I think what the cross appellee really misses, although we disagree and dispute about the conclusion that there was no factual issue, there's a legal question that has to be answered first, which is mitigation is always for the trier of fact. It is not a legal conclusion to be decided in a motion for summary disposition. And while cross appellee cites to Miller versus Miller for the proposition in his brief that somehow it can somehow turn into a legal conclusion, if the court looks at Miller versus Miller, and I apologize for not addressing this in a reply, Miller versus Miller didn't deal with mitigation at all. Miller versus Miller dealt with a negligence claim, and I'm aware of no case law, nor has it been cited by the cross appellant that supports the concept that mitigation is anything other than an issue for the trier of fact. And I would also point out that at trial, the court, after hearing the testimony, concluded that there was no problem with mitigation, and cross appellant doesn't even raise an issue that mitigation was not, in fact, an issue that was ruled on incorrectly after trial. I think that's an important distinction for this panel to make. With respect to the cross appellant's argument about puffery, I wish I could have provided you with an image of Judge Brennan's face when the plaintiff cross appellants testified that they knew that these apartments, in fact, go quickly, and then doubled down on their testimony that they were well aware that they had been searching for 2 years in this environment and in the city of Detroit, and every time they went to go find an apartment, it was already gone. Their contention in the trial court and in this court that somehow that statement of they go quickly is fraud was expressly defied by their own testimony at trial. And Judge Brennan, hearing that testimony and gauging the witnesses, made that conclusion and found that, in fact, was not a fraudulent statement from the appellant cross appellee in this case. Finally, Your Honors, the offer of judgment rule is a rule. MCR 2.405 very clearly sets forth what an offer is and what an adjusted verdict is. The appellee's own internal belief that somehow an objective number was anything other than the objective number that was in the offer is irrelevant to both the trial court's determination and this court's determination as to whether or not offer of judgment sanctions should have been granted. Very clearly, the adjusted verdict in the trial court was more favorable to the offeror, and that triggers the court rule and mandates the sanction. So what the court should do is affirm the trial court's judgment, and the court should remand the issue with respect to the offer of judgment back to the trial court to make a determination as to what those reasonable attorney fees are that should have been awarded as an offer of judgment sanction under MCR 2.
Is there enough in this record for us to find that the interests of justice do not weigh in plaintiff's favor?
Oh, I think there absolutely is, Your Honor, because all the case law that talks about what that interest of justice exception is, I mean, are very narrow, right? Like it's my favorite quote when you look at the case law around the offer of judgment sanction rule and its application is that the interest of justice exception is not a legal Rorschach test for the judiciary.
But don't you look at if there's a disparity in financial resources?
I think that is somewhat conflicted in the case law, Your Honor, because there is a statement that would say that, but then there's other case law that very clearly says it doesn't matter that one party has a greater financial standing than the other. So I don't think that there's clear law on that issue. But even if you applied it to this case, like the other factors for interest of justice are, is it an issue of first impression? Clearly, this is not. Was it reasonable or was it gamesmanship? Clearly, it was not. My client made an offer to settle potentially a $50,000 liability for $4,000 and some change.
They did that because they recognized they didn't want to go through the time and the expense of litigation in this case. And yet it was only the actions of the plaintiffs that compelled us to go through all of that. And that's exactly what the offer of judgment rule is there for, is to compel that negotiation. And I will point out, they can claim that they didn't understand what it was or that they believed it to be something different. They had an opportunity to make a counter offer, never did. So unless the court has any other questions, I'll follow up on rebuttal.
Questions?
Thank you, Your Honors.
All right, thank you.
Good afternoon, Adel Mucho. May it please the court, I would like to start with the argument about Miller and why we cited it. The citation there was simply as an example that even issues that are generally questions for the jury can and sometimes could be granted on summary disposition if the facts are undisputed. So we can cite, other than Miller, many other cases, usually in the negligence context, where courts have always said, generally, whether an individual breaches a duty is a question for the jury. Generally, causation is a question for the jury. And sometimes people file motions for summary on causation, and those motions are granted when the issues, the material facts, are undisputed. So our citation of Miller was just simply to acknowledge that although the question of mitigation is generally a question of fact for the jury or for the trier of fact, that does not prevent a court like the trial court below, who had in front of it undisputed evidence that for 8 months that unit was left off the market until December. And then December, the deposition, in January, the depositions were taken and they admitted that the unit was off the market until December. That was 8 months after they admitted that they knew that my clients vacated 2 days after receiving the keys. Those facts were undisputed at the time. The only facts that came out at the time the motion for summary disposition was filed that supposedly disputed those facts was an affidavit, a sham affidavit that contradicted the very testimony of the same person who's signing this affidavit. But I do want to, perhaps before I move into the points, I would like to address the issue about how the judge's face looked like when she heard that my client said, we know that these units go quick. And I'd like to take the opposite of that. Had my client said, well, we know that this unit had been vacant for 6 months, but we still believed you that those units go quick. That would have been an unreasonable reliance on a misrepresentation. The fact that my clients knew that these units go quick and this agent is representing these units go quick and there are other individuals who are interested in touring this unit, and the fact that they have that background made their belief in the urgency quite reasonable. Had they knew that the unit was vacant, or had they believed otherwise, that they knew that these units sit on the market for so many long, then for them to come to court and say their reliance was reasonable, it would have not been reasonable for them to make that reliance. So to counsel's point, I think even the court below it used that fact against my client for the wrong reason. It actually supported our reasonable reliance on that misrepresentation. Now, we are, of course, on the first issue we're raising is that the motion for summary disposition or for partial summary disposition, at the very least, as to the months of May through December, these are the months that the unit was undisputedly off the market. At the very least, those months should have been held that the defendant did not mitigate damages up until they actually put the unit back on the market. So at the very least, that's what the judge should have done and left the issue of the reasonableness of mitigation after the unit went on the market to determine at the trial. So really, the question, I guess, for the court is quite simple on the first issue that we're raising on the motion for summary, is that if this court believes that as a matter of law, someone can undisputedly wait 8 months, keep a unit off the market, put it back on the market after the representatives' depositions are taken and they're put in a spot to admit that they have not put the unit on the market, and then put it on the market for more than what the rent is under the lease that they want to hold my client to. If that undisputed evidence is still not enough to show mitigation, then we lose on the first issue. But it's our position that when it is undisputed that this was done, then the issue should have been determined as a matter of law. I would like to address a couple of statements made in my friend's reply brief, that he looked in the record and couldn't find where his client represented that there were other people waiting for this unit. Well, that page 24 of the appendix, quote, "I had other people that wanted to tour," close quote. That's the quote that was represented to my client on the day they were touring the unit. 2 days prior, they were out of their unit because it's a fire. They had no belongings. She knew that they were in a rush. They knew that units go quick. She said that the units go quick. She said there are other individuals waiting to tour this specific unit. 2 days later, they say, "We're out. The keys are with our attorney," which I personally was there. I knocked on their door at 3:30 p.m. on that day to give the keys, and they said, "We're not going to take them from you. Just put them in a drop box over there." So I'm not putting anything. I want someone to take them personally from me. But that's besides the point. The point is they knew that the unit was vacant 2 days after they started moving in and walked away. Said, "We're not doing this." Even their decision to say, "We're done, we're not going to pay," make it very clear they're going to breach. There was no question that my clients are not going to pay any rent. They were demanding, they filed a lawsuit demanding for the return of their money. And
what about the offer of settlement?
Yeah.
And more importantly, in my mind, did you satisfy the interests of justice for a possible waiver?
Yeah, yes, Your Honor. I believe the trial court said that their motion for sanctions under the offer of judgment rule is denied for the reasons stated in the response that we submitted. So I have to believe that the court actually looked at all the issues that we raised in our response as to the interest of justice. And at the very least, one of those satisfies that. So going on that point, I would start with the fact that the counter offer, when it was made,
when the counter offer was made,
when the offer of judgment was made by the other party, and that's under the Harbor case that we cite in our brief before this court, where there's a significant financial disparity between the parties. I think that on its own is enough for the interest of justice exception to apply.
How do we know that there's a big difference in financial resources between your clients and his client?
We look at, I'm sorry, you mean
what evidence,
proof?
Yeah, what evidence in the record shows a large financial disparity between the two parties?
So they do have, there is in the record, I'm not sure if it was actually attached as part of the appendix, but it should have been part of the record that came up to this court, which is my client's application for the rental of the unit. They've stated what their income is. It was barely making the rental monthly payments. It's not like, and perhaps.
But how do we know the financial resources of the defendants here?
Well, we do certainly know that they spent 37,000 on legal fees to get a judgment for 34,000. I think that in of its own is evidence that these individuals. Well, another point is the fact that they left the unit off the market. If the finances is an issue, they would have put the unit back on the market right away to mitigate any damage. Even if they're going to rent it for $1,500 as opposed to $2,200, they would have mitigated my client's liability.
So you want us to make inferences based on a mitigation of damages argument about how much financial resources they actually have? I mean, for all I know, defendants are on the verge of bankruptcy. I mean, or maybe not. Maybe they're extraordinarily successful and wealthy. I don't see anything in the record to suggest what the financial resources are of defendants here. Other than, your point that they spent a lot of money to win the case.
Right, and the point that the unit sat there for 8 months.
Okay,
when
so those are the two.
I think these are at least 2 points. Now, I will admit that, and as I've stated in our brief, is that once you get to those questions that you're raising, unfortunately, we didn't have that evidentiary hearing before the trial court. The court simply said for the reasons stated in our brief, and I would like to focus on my argument on the whether or not the offer of judgment, you have to look at it at face value or not. I think that's where, on that point, we should win. The fact that their offer of judgment does not on its face make clear that our clients are not going to get the $6,250 that they're claiming in their complaint, the return of this money that they're claiming in their complaint. Their offer of judgment specifically said, you'll get a judgment against you for $4,710 for the 3 months that accrued. You'll get a judgment against you on your complaint with prejudice, which means, of course, my clients, once they pay that offer of judgment, had they accepted that, they would have been bound by the lease, bound to make all the payments through the 2 years, lost the $6,250 that they put in, that they were claiming in their complaint, and paid on top of that $4,700. So for counsel to say, well, the rule is the rule, you only look at what the number says, but the reality is, that also goes to the interest of justice. The reality is that number is not truly reflective of what the true value it meant to them. At the time, we've made the calculation. At the time, had we accepted their true verdict is $57,000, because that would have been them keeping the money we paid, taking $47,000 that they're offering in their offer, and having a lease that is basically not subject to attack anymore because the complaint is dismissed without prejudice. And that means that my clients are going to be still responsible for the remaining rent after the 3rd month of breach. So that means they would have gotten all the rent they would have received at the end of the 2 years and everything that my client paid, period. It would have been the best result they could have gotten had they taken. And I called Mr. Cox and I put that in the brief below and here. Said, you understand what I'm telling you, that this is the reality is this is not an offer that makes sense. Said the offer says what it says, and he did not engage with me.
You respond with a counter offer that addresses some of your issues that you just raised.
I'm sorry.
Did you respond with a counter offer that tried, that would have settled
I,
everything, including any, I guess, liabilities that weren't expressly addressed in their offer?
Not formally under the rule. We have made offers from the very beginning when we start speaking to the representatives. We offered that they keep the 62, the money that was first deposited 2 days ago. We said, look, we really would let you keep this money if you just take.
But if it's, I mean, you say, you know, not officially or not, I mean, these were just lawyer discussions. I mean, if you didn't make a formal counter offer.
Then it's a denial. We rejected the counter, Your Honor.
Okay.
Right? But by form of silence, we certainly rejected it. I can tell you, my clients, when they understood that their complaint would be dismissed with prejudice, which means they cannot bring back the validity or raise the issue of the validity anymore forever and ever, they were just going to be bound by the lease. They said, we will never move into this unit. So even if we have to pay the entire lease. So that's the issue. But I believe, Your Honors, I think I would like to at least touch on the second point about why we believe that the court's conclusion on the issue of whether these units go quick and there are other individuals waiting in line to inspect this specific unit, whether that's puffery or not. I think the argument on the other side conflates what is representations as to present verifiable facts as opposed to puffery about future promises, like this unit will make you so much money, will make you a gold mine, like the cases that like the very case that the court relied on below. It was a case about a future promise, about and we cite in our brief about a unit that's going to make someone rich. It's going to be a gold mine. And those were promises. That's puffery, because it's talking about what the future will bring, as opposed to someone looking you in the face and saying, knowing that you just lost your home to a fire, telling you these units go quick. There are other people waiting in line to tour this, and pressuring them to pretty much just go and get this deal done. And then finding out later, as the evidence, not only at the depositions, but also at the trial, the evidence proved that Ms. Edmondson, who admitted saying these units go quick, she herself said to me, generally, a unit that goes quick is about a month or two, and then later admitted that this specific unit had been vacant for 6 months. So even when she uttered that statement to say this unit and there are other people looking to get to tour this unit, at that moment, she made a false statement. She didn't say this specific unit had been vacant for 6 months. Don't feel rushed. Again, I think that's a legal conclusion that the court should review de novo. And if the court believes that even when these statements are admitted, they still amount to puffery as to present facts, then that's the legal conclusion that this court will have to reach. We believe that the 3 cases on the issue that we cited and distinguished on section 2 of our argument pretty much cover this issue. And I would like to reserve the rest of my time. We are cross appellants.
All right. Thank you, Counselor.
The concept that a party's belief of the value of an offer should somehow be considered in determining whether or not the sanction under MCR 2.405 should be applied would completely turn the court rule on its head, right? Like, I think that what you're telling me is something different than what's on the paper, and therefore the court should not award the sanction, would essentially gut the court rule, right? And the court rule says that it's a mandatory sanction, and it already defines what the offer is and what the adjusted verdict is. There is no room in the court rule or in the judicial discretion in the court rule to go, well, I think you thought it was something different and therefore I'm not going to hold you accountable for it.
Would the effect of the offer of settlement of judgment have been that they paid whatever it was, 4,000-ish, but then they also had to pay all of the rest, the balance of the 2 years? Or was it, you pay us 4,000, everything else is dismissed on both sides and we go our merry way?
Your Honor, we operate the practice of law in an adversarial system. And I preface my response to this court only because it's not my job to tell opposing counsel how to do his. And the answer to the court's question is yes. You're involved in litigation where a complaint has been filed and a counter complaint has been filed. The counter complaint specifically asserted, I want $52,000 from you for the breach of the lease. They said, I want $6,000 from you because the lease never should have been honored and I want all my money back. The offer said, I want a judgment against the plaintiffs for $4,000 and some change. That accounted for all the rent that was owed through that date, and I want you to dismiss your claim with prejudice. So the net of that offer on its face is about $10,900. I'm keeping the $6,200 you paid me, and you owe me another $4 and change. The case is closed. A judgment is entered. It's final. It's res judicata on additional issue in the future. I don't have to explain that to brother counsel. He has to figure that out for himself. He didn't. He didn't make a counter offer. He rejected it. And I do just want to go back to your prior question, Your Honor, about whether or not the interest of justice applies. And like I said, it does conflate, right? Like Harbor talks about one of those things being significant financial disparity between the parties, right? Ludens, which is also a published opinion, although decided before Harbor, specifically says that the disparity of economic standing between the parties nor the frivolousness of plaintiff's case is sufficient to justify the denial of attorney's fees. So I think there's some conflicting case law on that particular issue. But what I don't think is conflicting is when you're talking about the interest of justice exception, it is a very narrow exception. And Ludens, I think, hits it on the head. When you look at all of the various aspects that the court is supposed to consider to see whether or not that exception applies, Ludens said, and I quote, the common thread in these examples is that there is a public interest in having an issue judicially decided rather than merely settled by the parties. In such cases, this public interest may override MCR 2.405's purpose of encouraging settlement. And that just makes sense, right? Like if I'm, fighting some new issue for an impoverished person who's trying to overcome, some gigantic opponent on the other side, and I want to fight that fight for the good of the public, I shouldn't be punished for doing that. That's not this. This is not a public interest case. This is a person who had buyer's remorse on a lease, who made really bad decisions during litigation. This is not the kind of exceptional circumstance that exception should apply to. Thank you, Your Honor.
Thank you, Counselor. Rebuttal?
Your Honors, my argument about what the offer of judgment said is not what I believe. It's exactly what the offer said. And counsel actually made my point for me. He admitted to Your Honor's question that the net would have been different than what the offer said.
Yeah, I think you said the net at best would have been 10.
At that point, and he also admitted to your question that they would have still been responsible for the remaining of the balance of the lease.
I don't think he said that.
In any event, I think you're only really at the podium to give rebuttal on your cross.
Yes, Your Honor. So I guess I would rebut that to say that we figured out that their offer of judgment is not what it said on its face. We figured out that when our complaint is dismissed with prejudice, means they are still owed the remainder of the lease that is not on the face of the offer. And these arguments were made in front of the court and the trial court agreed with us. As to the interest of justice, I think if the court
Again, that's
really
not part of
gets
your
to,
cross appeal, is it? Isn't that part of the main appeal?
I thought I'm rebutting his arguments, Your
You're
Honor.
rebutting on the cross appeal. That's the only entitlement you have to rebuttal is as to
Okay.
your cross appeal.
I see your point, Your Honor. Well, then, I think if the court really gets to,
Again, that's not part of your cross appeal, is it? Isn't that part of the main appeal?
I thought I'm rebutting his arguments, Your Honor. I see your point, Your Honor. Well, then, I guess I have to rest because he didn't raise any arguments there. So thanks.
Thank you, Counselor. This matter is submitted. We'll take a short break at this time. I know many of you have been here all morning, but we'll be out shortly to finish the docket. Thank you. Good afternoon. Thank you for your patience this afternoon. My apologies. It has been a long morning. We are going to start our 11 a.m. docket at this time, calling item number 9, docket number 370455-D, Cecily Hoagland. Did I say that correctly? Cecily Hoagland versus 1300 Lafayette East Cooperative.
Yes, I'm sorry. What was the case number again, Judge?
370455-D.
I misheard you.
Oh, no problem.
All right. Good afternoon, Judge.
Okay. One moment. How much time would you like for rebuttal? Reserve for rebuttal?
Let's try 10 minutes, although I hope to try and maintain my composure just to get through the presentation of the issue.
All right, counsel, you may proceed.
Judges, my name is Odell Jones. I'm appearing before you here as a pro se litigant. I have listened intently to the cases that were called before me, and I want you to know I'm humbled to be here, and I'm grateful that we're just talking about my home and not my life. It has been a very trying 9 years for me. And in adhering to Judge Bazzi's statement earlier, I'm going to state simply that the appellant should prevail because an offer is not a contract. An agreement to settle pending litigation is supposed to be a contract, and it should be governed by the legal principles applicable to the construction and interpretation of contracts.
Wasn't there a settlement agreement made on the record? I believe in the summer, maybe it was August or September, I forget, where the parties agreed to material terms, and the one condition was that defendant had to get board approval. And I understand, and I think you were correct, reading into the record, you seem to be agitated or upset that the board was trying to add a new condition on, right? The dismissal of, I think you had a civil rights case or action. Is that correct?
It is correct that there was a...
So if the board was trying to renegotiate the settlement, and I can see why, I mean, I would certainly be upset if I thought we had an agreement and then a board tried to renegotiate, but you seem to have kind of stuck to your guns throughout the lawsuit of, no, we have an agreement, And it wasn't until that January, February, where it seems like you took the position of, well, wait a minute, now we don't have an agreement. Am I misunderstanding the record?
Well, I think you understand a portion of what was occurring, but as it relates to the material terms that were placed on the record, I'm not sure that you understand the totality of that. The trial judge was very careful when we went through this exercise to make sure that each element that was a material term of settlement was clearly stated and he went to each party and then said, do you agree? And asked if there was anything else that the party wanted to add. Is this it? And he went item by item through what really was not an exhaustive list of elements that were supposed to represent material terms for settling the dispute. And he would ask, now you can discuss other things, but you understand that this is not material. You understand that. And all of the parties acknowledged. And so then we end the litigation, and what is supposed to result from this is a settlement agreement because all the terms have been placed on the record.
That is the settlement agreement.
Well,
I mean, putting it on the record is the settlement.
so would it have been then, Judge Swartle, a settlement if 1300 did not accept the terms?
Well, that was the one again, correct me if I'm wrong, but that was the one condition that remained open of, okay, this is a settlement. The only exception or the only condition is that, defendant needed to get client sign off, so the board had to sign off. And from what I could understand from the record, there was some hearings after that where I thought you made the position of, we have a settlement, we're done. The board keeps trying to renegotiate it, we're done. And I think you were right in that position. And it seems like that was your position up until that January, February timeframe, where you seemed to basically say, okay, now we don't have a settlement. Am I not understanding that properly?
No, that was the time frame in which it was disclosed. So from the August the 4th hearing to the period of time in January or February, it had never been disclosed, at least not to me, that the board had any issue with any of the material terms that were placed on the record.
Right. They wanted you to agree to dismiss or not pursue a civil rights claim, correct?
Correct, but that was
that was not a term.
right. And so it was not of any consequence to me. As far as I'm concerned, we still have the material terms that are on the record. That is the agreement, and Judge Sullivan made it clear that the parties could have other discussions, but they were not material to the settlement. And so my interpretation or belief was that all of that was nothing more than just discussion, which the judge allowed. It wasn't until the email that occurred in late January, wherein counsel for 1300 indicated my clients are still having issues with the terms for repayment of carrying charges. At which point I said, you know what? We've been doing this now for 6 months. It's inexplicable. All you really needed was the transcript because that was the agreement.
Right. But I mean, that's where I'm having the disconnect. I agreed with everything you just said, which was there was an agreement. There is an agreement, and maybe a motion for sanctions against defendant for dragging their feet or trying to add in new conditions. That might have been appropriate, but that's different than then calling into question the very existence of the agreement to begin with.
Well,
do you see the two different?
I do, Judge, but I think what's being overlooked or not recognized is that those material terms which form the basis for the agreement were subject to the approval of the board. Without their approval, there is no agreement. There's merely an offer. If 1300's board of directors had simply said, we accept the terms that were placed on the record as the agreement between the parties, those are accepted. Now, we want to talk to you about some other things But we recognize that this doesn't have anything to do with the agreement that we have just approved. We've approved this agreement. That never occurred. And it wasn't until that late January or February, I believe it was, of the following year that it finally gets disclosed that not only have they not accepted or approved the terms for repaying carrying charges, but they've now added a series of other conditions that they want to have accepted, which were never part of the material terms that were placed on the record.
But let me ask you something. I mean, ultimately, well, let me ask you this. Had you all left court that day and they would have come back and said, all right, we agree with all the conditions, agree with all the terms that were discussed in court, would that have been an agreement in your mind?
I believe it would have. It would have been an acceptance by the board of the material terms that were placed on the record.
Okay. But you're saying because it occurred 6 months later that it wasn't an agreement?
Well, I would beg the court to show me where it ever occurred.
Well, you ultimately go in front of the court, and in front of the court at the time that, Judge Schwartzel indicated you were understandably frustrated, right? Counsel of record from opposing counsel had agreed to terms subject to the approval of the board, and then they came back and wanted to change some terms. But then ultimately, when you are in front of the court, and I forget exactly what that date is, all of the original agreement that was entered, that you had all agreed on the record in 6 months prior, those were the only terms that were agreed to, or that opposing counsel was coming forth with. Do you understand what I'm saying?
I believe
Was there
I
something
understand.
different?
I believe I understand what you're saying, but I don't believe that that record reflects that. If I'm not mistaken, what you're saying is at some point, opposing counsel presented to the court for entry an order that was reflective of the material terms that were placed on the record and didn't endeavor to add, or change anything else.
Isn't that what happened 6 months later in court? It happened, and then opposing counsel sent an order that reflected that you did not sign off on, the judge accepted without your signature.
So, Judge, I believe that the trial court record, reflects what occurred. They being the appellees, initially presented a motion to enforce the settlement. That was the first motion. We responded. Then they presented a second motion to enforce the settlement, and we responded. In the response, we made clear where the order that is attached for entry and enforcement is inconsistent with the transcript of the hearing that placed the material terms on the record.
So there were the material terms placed on the record during the August 4th, 2023 hearing.
That's correct.
The order ultimately entered by Judge Sullivan. How did that order that he signed on your behalf, how did that order differ from those material conditions put on the record in August 4th, 2023?
You will find nothing in the 8-4 transcript that sets forth those material terms, anything governing the sale of the unit beyond the bylaws or the governing documents of the cooperative. To, after that hearing, try to impose a condition on the sale of the unit, which is not part of the settlement discussion and is not part of the bylaws.
But is that in the order that Judge Sullivan ultimately approved?
Well,
because here's the problem that I'm having is that we see a lot of times where you'll have a settlement put on the record, and then it takes months because the parties are bickering back and forth. They misremember And the judge always has to point them back. We talked about the material conditions. There were these 5. That's what the settlement agreement. And then the lawyers will ultimately get together and it gets resolved. This seems similar to that, which in terms of you had a settlement and then it just took a while to get the order to reflect the settlement. And it unfortunately happens. And I understand. I mean, I would be very frustrated if I was in your shoes because it did seem like defendant was trying to add additional conditions. But ultimately, looking at Judge Sullivan's order, I'm trying to figure out how did his order differ from that August 4th, 2023 material points that he put on the record.
And without comparing it, here today, I can't answer that question. All I can tell you is
but isn't that what we have to do to see if they line up?
I believe I've incorporated all of those in my exhibits and my brief. And all that I can say with respect to that, is that at the time I declared that the offer was withdrawn, I know for a fact that what had been submitted to the trial court, which I reviewed before I made that withdrawal, was not consistent, with the August the 4th, transcript where all material terms were placed on record. And in fact, I remember distinctly saying, I can't wrap my head around this. How is it possible for us to get this far afield? How is it possible to get off track like this when we made a record in court? What is this? And when it turned into, well, my clients are still having issues with the terms for resuming the payment of carrying charges. At that point, it became manifest to me that we weren't just waiting for some wordsmith document to be crafted. It was, in fact, the board's repudiation of those material terms. At which point, I said, I'm moving on. And Judge Sullivan then said to me, well, you can't withdraw your offer. Well, so what are you going to do? I said, I don't know, Judge. I'll have to examine that after the fact, but I'm done with this. It should not have taken all of this when the parties merely needed to say, those terms are accepted. Let's discuss some other things. 90 days later, the unit could have been restored. It could have been put on the market. People could have gotten on with life. This has been 9 years. My granddaughter was 3 when she visited one summer and said, Pop, your place is broken. And it's still broke to this day.
Mr. Odette, I don't want to interrupt you, but you asked for 10 minutes for rebuttal. You have 13 minutes right now. You're at 13-minute time frame. So I just wanted to let you know.
Well, my position, judges, is simply that the offer was not accepted before it was withdrawn. The offer was not a contract. It was an offer, and it was withdrawn. And if the parties have accepted it since, I have no knowledge. But the offer was withdrawn. I'd like to reserve any time left for rebuttal. I appreciate your attention.
Good afternoon, Your Honors. Dan Saylor appearing on behalf of the defendant. So it sounds like Mr. Jones is one of his principal disagreements with our view and the trial court's view of this matter is that the fact that material terms were clearly identified and agreed upon by the litigants and agreed to be the material terms
It sounds like Mr. Jones believes that that means that any additional terms that ended up in a final settlement document were not allowed. And I think that because I believe he said that when you look at the end of it, when you look at the final document, Judge Swartzley, you asked what about that final document is inconsistent with what was agreed on the record in August. And the answer was that there were various terms that were not stated as material terms. But it was clear to everybody at that August hearing that there would be additional discussions and additional details to be worked out to finalize a total resolution. But the judge got everyone to agree that in that event, separate from these material terms, if you couldn't work those out or come to me and we could work them out together, that we would get a facilitator, but one way or another, those are not going to disrupt
What about
the settlement.
What about the argument that the board that board approval still needed to be had over those material terms, and therefore board had not accepted by the time Mr. Jones withdrew in January, February?
Right. Here's what I believe that Mr. Jones is missing. That when the counsel for defendant went back to the board and ran this by them, when that discussion with the board resulted in an approved proposed settlement document that was sent to plaintiff's counsel and Mr. Jones, that inherently means that everything in there has been approved by the board. Because certainly if they didn't have any objections and signed it, the board would have been bound. So that was an approved, everything in that proposed document was approved. And in
It's
fact,
a package, wasn't it? I mean, what if Mr. Jones objected to some of the terms in that?
Well,
were
that
not material terms at the August hearing?
that in fact happened. This is where it gets,
Right. So
the
I
key
mean,
portion
it's
is in
not-
February of,
Hold on. You can't just say, well, the parties agreed to the 5 important things, and then the other 7 lesser things they disagreed on, but there's still a meeting in the mind on 5. I mean, isn't there an argument that here was the settlement agreement that the board approved? It had some other conditions that Mr. Jones did not agree with. So we don't know that the board agreed on the settlement terms. We just know that the board agreed on the settlement terms plus additional conditions that Mr. Jones rejected.
no, you're right, Your Honor. Look, what happens, and this is the key portion, what happens in February of 24 at that point, in the beginning of February 24, a revised, I think you call it the first revised document because they'd already gone through one round of changes back and forth. This revised document was proposed to the plaintiffs and the co-plaintiffs counsel. And that was on February 2nd, 24. On Sunday, the 4th, and the parties met before the court. It's not on the record, but this is all confirmed in the February 5 transcript, which was on the record. So they're together on Friday the 2nd, and they all agree, and the record reflects that they went through it line by line. They were very hyper-focused on it, apparently. I wasn't there. But, and the result of that was that Judge Sullivan asked the plaintiffs to go through the document and redline exactly what you want changed. But everything else, this was confirmed on the February 5 hearing, which was on the record. So there's a transcript of that. Everything else is agreed upon. Both sides agreed upon. The fact that the board proposed it means that they've agreed to it. And the fact that they're not redlining it means that the plaintiffs have agreed to it. But they identified 5 points that the plaintiffs did that they want changed. So those 5 points. And so on the 5th of February, the judge said, okay, so you've got these 5 changes that you, Mr. Jones, would like. And Mr. Gillooly, for the defendant, said, and I agree that we can get those changed. I believe we can. It'll be my job to get the board to sign off on those 5 changes. So that's where things stood on the 5th of February.
You're making, I mean, you're almost making Mr. Jones's argument for him. I have no idea right now when the agreement is. Was the agreement in August, and did the order that Judge Sullivan entered have material conditions in addition to those?
No, the agreement was in August, and it was ultimately all those material elements were approved and are in the final document.
And were there additional conditions that Mr. Jones did not agree to?
No, they're not. There were additional conditions, and they were ultimately resolved in favor of Mr. Jones. All 5 of those remaining elements that still need confirmed approval were resolved in favor of Mr. Jones. Now, I know he says, I don't think that he disputes that. I think what he says is, yeah, but by that time I had withdrawn my offer. I think that's his position. However, you need to look carefully, and it's outlined in my brief, that what happened when he says he's withdrawing his offer. Number one, I don't know that he could withdraw the offer, but the fact is, Mr. Gillooly had communicated with them, I'm still having trouble with, the board is still having trouble with these 2 out of those 5 terms. One of them was that civil rights, getting rid of the civil rights. They really wanted that in there to be released. And he said, the board's still having trouble with that. So Mr. Jones then communicated, well, it sounds like they've rejected the whole thing. I'm withdrawing my offer. That same day, Mr. Gillooly replied by email, well, I didn't say that. I didn't say they're rejecting it. I said I was having trouble with them, but good news, they've now agreed with everything except for still squirrely about that civil rights thing. That was the last thing. And that's not one of the material terms. So this could not be something that would squirrel the whole agreement. And immediately in response to that, Mr. Jones sent Mr. Gillooly another email saying, again, expressing frustration about all this, saying, my offer of settlement is not, and this is a quote, my offer of settlement is not a negotiation tactic for your client to modify however they see fit. Please reply to this email whether the proposed settlement terms are accepted. That means even if he thought that he was withdrawing his offer before, it's back on the table. He has just said that, okay, sounds like there's 1 term left. Please advise.
And in response to that email, did you say?
They gave up the civil rights thing and said, we'll take that out as well.
I mean, I would be extremely frustrated if I was plaintiff in this case with the way that your client, with the way your client and the board continually try to renegotiate, which should have been a done deal. And if there had been a motion for sanctions, then maybe that would have been something that Judge Sullivan could have taken up, but it doesn't look like that was put on the table.
So I would just rely then on that chronology, that it's really undisputed that all of these, both the material and these additional less, I don't want to call them immaterial, that sounds wrong, but non-material.
To Mr. Jones.
I'm sorry?
They were certainly material to Mr. Jones, even if they weren't identified as material terms of the settlement in August.
Well, I mean, he defines material explicitly in his brief. Material was the term used over and over and over again in the August hearing, and the judge was very clear about these, and there were about, I don't know, A through H or something like that, of material terms. And he was, as you've seen the transcript.
But my point is, if the board is wanting to add additional terms, some of those additional terms appeared to be material to Mr. Jones. And if they were going to be material terms, they should have been on the record, or they should have been agreed to before the settlement became complete.
Well, luckily, each and every one of them were ultimately, they did capitulate and allow him to include those, we're going to take out the civil rights thing. The insurance company is not going to be released, things like that. I believe my view of the record is that all those, let's just say lesser important.
Just ancillary.
Yeah, that those issues would arise, and there's going to be some sort of workout between the two parties to have those additional, for instance, one of those 5 remaining details was, how are we going to get our $30,000 check? And they talked about, okay, well, look, because that wasn't specified, the details were not specified. The fact that they get it is a material term, but the question came up about, well, how do we divide the month, and how are we going to get it? And
It's,
it
I mean,
was
these are
decided
all,
30,000.
these are all details that, fine, they weren't in the material conditions, or
From
material
August.
settlement conditions from August. But then it's incumbent upon your client to settle those 5 and get that done. And you can argue for a year about the ancillary terms, but the 5 should have been handled cleaner than what they were handled here. And the board should not have kept trying to tie or smuggle other conditions back into the main settlement agreement. I mean, again, if there had been motions for sanctions against your client, I think that would have been something that Judge Sullivan could have taken a close look at, but it wasn't done.
I appreciate that, Your Honor.
So your representation here today is that there's nothing in Judge Sullivan's ultimate order that is other than what was stated at the August hearing, to which Mr. Jones, it wasn't resolved in Mr. Jones's favor. If there's nothing in that order to which he would have reason to object.
Well, they identified 5, and he prevailed on all 5 of those last remaining issues. Everything else that was not redlined, he is explicitly on the record of accepting. The only differences were those redlined items, and those ultimately were 100% resolved in plaintiff's favor. Thank you, Your Honors.
Mr. Jones, you have 12 minutes.
I want to be clear that at no point in time during the course of the trial court's proceedings did I agree to anything other than the material terms that were placed on the record during the August 4th hearing. Any belief or suggestion or inference that occurred will simply not be supported by the record. It didn't happen. I would never have been unsettled by an ongoing discussion about other terms that could have been added, because Judge Sullivan was very clear and careful during the course of the hearing to make known to all parties, you can do that. A group of you can get together one-on-one, Mr. Jones, and I don't know how many people from the board. That's not a problem. It's got nothing to do with the material terms that are placed on the record. What that conveys or says to me is that with the material terms that were placed on the record, the parties should have been able to enter into an agreement. The board accepts, it's done. That doesn't preclude additional discussions afterwards down the road. A material term was the dismissal of the 36th District Court summary proceeding. Pursuant to 2.504A, that dismissal required nothing from the appellant. All that opposing counsel had to do was prepare the motion to dismiss the summary proceeding and release the escrow. Didn't happen. A material term was resuming carrying charges. In fact, if you look at the transcript, Exhibit B, page 8, line 14 through 22, it outlines that. How is it possible that at the time the order is withdrawn, we're having issues with the timeline for resuming carrying charges if all material terms have been accepted? I've already covered the issue of the sale. The transcript, page 8, lines 17 through 18, page 9, lines 5 through 6, page 10, lines 24 through 11, page 12, lines 17, and page 13, line 48. I'm sorry, page 13, line 14. All cover the sale of the unit. There's nothing in the transcript about adding additional terms governing how the unit is sold. So I'm at a loss for trying to understand how all of these caveats and exceptions are tantamount, to an agreement or an acceptance or an approval of material terms when I just cited 3 specific material terms that clearly they were having issues with. This has got nothing to do with civil rights cases, nothing to do with any other extraneous issues. These are all material terms on the record. And a simple answer, yes, they've all been accepted.
But they're part of the judge's ultimate order, aren't they?
If the order contains additional terms, I did not agree to them.
And does it? Does it have additional?
At the time I withdrew the offer, the last document that had been submitted to the court for entry was not a document that was consistent with those material terms, which is why I incorporated all of those as exhibits to my brief.
But again, I think to Judge Boonstra's point, set aside the flurry of documents going back and forth and red lines and whatever, but the actual order that Judge Sullivan signed and entered, did that have material conditions above and beyond those that had been agreed to back in August?
I can only say, Judge Swartle, that they must have, because the orders that were submitted to the court for entry were submitted as a part of a motion to enforce the settlement, which was responded to. And in my response, I indicated where that proposed order that was being presented for entry, differed from the material terms that were placed on the record. I didn't bring the final order that was appealed from and compare it, to the order that was submitted to the court before I withdrew the offer. But I would submit to the court that I would not engage in such subterfuge or deception. It would be inappropriate, and I have never engaged in that conduct and behavior.
Thank you.
Thank you so much.
Thank you very much,
Nice
Mr.
job.
Odell. All right, this matter has been submitted. Moving on to item number 10, docket number 377606-T, in re guardianship of DB. I believe both appellee and appellant are appearing over Zoom or remote for oral argument. All right, counselor is Miss Parker.
Here we go.
Yes, good afternoon, Your Honor. Guy Conti on behalf of the appellant.
And Elizabeth Parker appearing on behalf of the appellee.
Your Honor, preliminarily, I don't, upon review of the briefs, Your Honors, and discussion with Ms. Parker this morning, the appellant has agreed to, on the record, dismiss the appeal.
I'm guessing because it's moot, you've had your evidentiary hearing?
For a number of different reasons, Your Honor, including that, but I don't believe that I can ethically go forward with the appeal at this point.
All right, yes, then we'll enter an order to that effect. Thank you very much.
Thank you.
Thank you.
Moving on to item number 11. Docket number 376157-T, N. Ray Carson Minors. We just have appellant that is endorsed for our argument. Has anyone appeared? I'm sorry? All right, no one having checked in and there being no requests for remote oral argument at this time, item number 11 will be submitted. Calling item number 12, docket number 377672-T, N. Ray Deborn Free Minor. We have endorsed for oral argument, attorney for appellant. Has anyone checked in? All right, no one having checked in and no one having requested remote oral argument at this time, this matter will be submitted. Calling case number, item number 13, 374275-D, People of Michigan versus Ricky Brown Jr. I have both sides endorsed for oral argument. Counselor, how much time would you like for rebuttal?
Probably the whole time, because I'm going to introduce myself and say hello. And hopefully be received well, that I am not going to argue. I'll just answer any questions you may have. And just reserve time for rebuttal.
Any questions?
Let's have your appearance first. You were gonna.
That's a great idea. Kimberly Stout on behalf of the appellant, Ricky Brown Jr.
Thank you
We've
very
been
much.
waiting a long time today to say that.
Thank you.
Good afternoon, Amanda Smith, Wayne County Prosecutor's Office, on behalf of the people of the state of Michigan, the appellee in this case. It has been a long day. I am always inclined to rest on my brief, stand for questions. But in the car ride here this morning, I did think of something that I wanted to float out there for the court's consideration. And that is an issue too. The question about jail credit, Mr. Cripps as counsel for Mr. Brown below, and as sister counsel, I believe in her brief to this court now, everyone seems to agree that the statute plainly did not afford Mr. Brown jail credit. So the argument really is based on the idea that I think it's footnote 10 in Atkins gives a trial court judge like freewheeling discretion to just give jail credit if they feel moved to do so. Judge Van Houten did not agree with that view and she denied relief. I explain in detail in my brief why that was appropriate. But just in happenstance, the way life is, after I submitted this brief, within a matter of days, I was before Judge Van Houten, waiting to be called on record in an entirely separate case. And I watched a defense attorney make this exact same argument, relying on footnote 10 in Atkins to ask for his client to get jail credit. And I think in the research I did in this case, there's just not a lot of helpful guidance for trial courts in this area, really making it clear about that dicta in Atkins. And I know that the Supreme Court kind of brushed it away. It may have been an ITSAC indicating, that footnote is dicta. And even if it wasn't, we're just not going to follow it because we distinguish it. This case is always also distinguishable for the reasons explained in my brief. But because of that, I do want to float it out there that it may be helpful to consider publishing an opinion because this issue does come up quite a lot. And then I watched in real time all of the parties kind of scramble because I think it was an unanticipated argument. And on the fly, you're trying to distinguish a footnote and you don't have a lot of nice guidance in a published opinion from this court that specifically addresses that. So while it's not mandatory, to publish, I do think in an unusual case such as this, I just wanted to say you may want to consider it.
Any questions? No, thank you very much.
Okay, thank you.
Any rebuttal?
I hate to say anything, but just can't help myself. Thank you, Your Honors. Briefly, I don't know that this is the case to address the issue of this dicta. I don't disagree that it is dicta, but I just wanted to point out does have some egregious facts of a very long period of time where he wasn't sentenced on the matter here in this state. So there is kind of like perhaps a manifest injustice argument there or something like that a trial court could, look at the dicta for that reason. But that's really all I have to say. So thank you. Unless
No.
you have questions.
I don't.
Thank you.
Thank you very much, and thank you for your patience this morning. Item number 13 will be submitted. Calling item number 14, docket number 372097-D, Interstate Restoration LLC versus Chalmers Square LDHALP. Nobody is endorsed for oral argument, so at this time, this matter will be submitted. Calling item number 15, docket number 373067-T, People of the State of Michigan versus Zabidi Alfonso Green. No one is endorsed for oral argument, so at this time, this matter will be submitted. Calling item number 16, case number 373792-D, GJP 2018 LLC versus Christopher Thacker. No one is endorsed for oral argument. So at this time, this item, I'm sorry.
I'm not endorsed. I apologize, Your Honors. Suzanne Dewan. Or repeat numbers.
Why don't you come up to the mic?
Yeah, why don't you come up to the mic?
Certainly. Suzanne Stepich Lawan. I am the attorney for the defendant appellant in this case. I wasn't sure of the procedure, so I'm here if there would happen to be any questions.
Do we have any questions?
I don't.
Thank you
Thank
very
you.
much, Counselor.
Thank you.
And I appreciate your patience this morning as well. All right, at this time, this item will be submitted. And that is the end of our docket. Thank you.